if you're here in person for HB 216 and you're a proponent, feel free to come on up.
Thank you, Dr. Kaufman.
Good afternoon and welcome back to the House Judiciary Committee. This is January 27, 2026. We will start our bill hearings. Our first bill is House Bill 216 with Delegate Kaufman. Delegate Kaufman, whenever you are ready, you may begin. Excuse me, I said that, but just 1 second. Members and audience, I need to leave. We are having a Rules Committee hearing that is starting right now, so I'm going to leave, and Delegate Embry is going to assist. So Delegate Kaufman, whenever you're ready.
Good afternoon, Madam Chair. How about that? Something special. Vice Chair Davis and members of the Judiciary Committee, for the record, my name is Delegate Aaron Kaufman, and yes, I really do miss my Judiciary family. And I'm here today to request a favorable report on HB 216, benefits exploitation. This bill is bipartisan, as Delegate Tomlinson is on the bill, as well as the fact that the bill is co-sponsored by Senator Chris West. The bill addresses a clear and growing gap in Maryland law, where while our statutes prohibit financial exploitation of vulnerable adults, generally, they do not explicitly address the intentional diversion or misuse of government benefits, such as SSI, SSDI, SNAP, or Medicaid, that many older adults and people with disabilities rely on for basic survival. I want to make very clear that I've worked extremely closely with the Office of the Public Defender to try to address their concerns. And you'll see an amendment that was sent out by my staff yesterday. We did reduce the penalties and base it on the amount of financial losses. But I also think it's worth noting that this bill, when it was last on the House floor, passed 137 to nothing. But I'm a nice guy. I'll keep working with the public defender. Adult Protective Services in Maryland report consistent year-over-year increases in financial exploitation cases, particularly those involving misused public benefits. National research shows that financial exploitation is the fastest growing form of abuse, resulting in billions of dollars in losses annually, with adults with disabilities experiencing exploitation at a rate several times higher. And I do want to indicate that this bill is supported by the AARP, by the Department of Human Services, the Department of Aging, the Alzheimer's Association, the Governor's Office of Deaf and Hard of Hearing, and so many others. So I'm very proud of that. Investigative reporting by the Baltimore Sun found that despite a 2023 law making unlicensed assisted living facilities a felony, more than 100 so-called shadow senior care homes continue to operate. Advocates warn these function as hidden systems of exploitation, sometimes described as senior trafficking, where vulnerable adults are isolated, abused, and have their benefits systematically diverted with little effective enforcement. You can read the rest, but what I really think that it closes the gap by creating a defined criminal offense of benefits exploitation, prohibits knowingly recruiting, harboring, or obtaining an individual for the purpose of appropriating their government benefits. The bill also prohibits profiting from, participating in ventures that exploit individuals for their benefits, and clearly defines key terms such as coercion, deception, exploitation, and isolation to guide enforcement. For these reasons, I respectfully request a favorable report on this common sense legislation that cracks down on a heinous crime. Thank you for your time, and again, I miss you all.
Thank you so much, Delegate. And who would like to go next?
Good afternoon, members of the House Judiciary Committee. Thank you for the opportunity to support House Bill 216, Benefits Exploitation. My name is Sarah Westrick, Advocacy Director for AARP Maryland, one of the largest membership-based organizations in the state, encompassing almost 850,000 members. AARP thanks Delegate Kaufman and all the co-sponsors of this legislation. HB 216 is a crucial piece of legislation aimed at preventing the exploitation of vulnerable individuals and safeguarding their government benefits. Exploitation of vulnerable individuals, particularly older adults and those with disabilities, is a pervasive issue that affects far too many Marylanders. These individuals are often targeted by unscrupulous individuals who seek to exploit their trust and vulnerability for personal gain. This bill seeks to address this issue by prohibiting the recruitment, harboring, transportation, or obtaining of an individual for the purpose of appropriating their government benefits through deception, coercion, exploitation, or isolation. AARP Maryland believes it is important to highlight the critical link between benefits exploitation and unlicensed care facilities. These facilities often operate in the shadows, providing substandard care to vulnerable individuals. By prohibiting the exploitation of benefits, HB 216 offers one part of the solution to preventing the proliferation of these unlicensed facilities. This legislation will help to ensure our state's most vulnerable citizens are protected from those who would seek to harm them and that they receive the quality of care they deserve. I urge the committee to issue a favorable report on HB 216. Thank you so much.
Thank you. You'd like to go next? Yeah.
Yes. Good afternoon, Acting Chair Embry and members of the committee. My name is Andy Culp, and I'm the Executive Director of the ARC Maryland. And the ARC is considered the largest statewide advocacy organization dedicated to protecting and advancing the rights of people with intellectual and developmental disabilities. And so I'm here in support of House Bill 216 because we believe it closes a critical gap in Maryland law by explicitly recognizing and criminalizing the financial exploitation of government benefits through coercion, deception, and isolation. And financial exploitation is something that I've unfortunately seen in my 3 decades of service to the disability community, and the prevalence is only growing. In my experience, it was typically people with representative payees, unfortunately typically family members, who would obtain the benefits through repayeeship of their loved one, and then divert the funds from the Social Security benefits to pay their own bills while ignoring the obligations of the person with disabilities who was in our care. While states like Illinois and California have taken up this issue, enacting laws that would provide prosecutors with clear authority to act in these serious cases, Maryland unfortunately lacks an explicit statute that would address the intentional diversion or misuse of vulnerable individuals' government benefits. But I believe that House Bill 216 would address this very issue. So for this reason, I ask for a favorable report on House Bill 216. Thank you.
Good afternoon, members of the committee. My name is Jessica Spraker, and I'm a staff attorney with Maryland Legal Aid, and I'm testifying in strong support of House Bill 216. Maryland Legal Aid is a nonprofit law firm that provides civil legal services to people in Maryland who are low income and vulnerable. Each year, we assist thousands of individuals who rely on public benefits, including SNAP, TDAP, TCA, and Social Security. Many of our clients also depend on Medicare, Medicaid, veterans benefits, and are people with disability and older adults. For these individuals, public benefits are not just supplemental, they are vital to daily survival. As our population ages, we are seeing a very troubling corresponding increase in abuse and financial exploitation, particularly targeting older adults. House Bill 216 addresses a significant gap in Maryland law by making it illegal to obtain another person's public benefits through isolation, deception, coercion, or exploitation. This issue is not theoretical. Maryland Legal Aid has represented clients directly impacted by this type of exploitation. In one case, we assisted an 82-year-old woman with disabilities whose granddaughter brought her to Maryland under the guise of a visit, then isolated her, concealed her identification, and took her Social Security benefits, her pension, and her rental income for more than 18 months. Our client was left without access to her own money or identification and unable to return home. The exploitation only came to light when her granddaughter attempted to obtain guardianship to permanently seize our client's income. This conduct involved deception, isolation, and theft of government benefits from a vulnerable adult, precisely the type of harm House Bill 216 is designed to prevent. Maryland Legal Aid strongly supports efforts to prevent benefits trafficking and exploitation, particularly when it targets older adults and people with disabilities, and we respectfully urge the committee to issue a favorable report on House Bill 216. Thank you.
Thank you all so much. Are there any questions? Delegate Taylor.
Thank you, Madam Chair. Hello, Delegate Kaufman.
Hello, my friend.
It's so great to see you there.
It's great to see you.
And I am just going to channel you as a member of this committee and ask you, Delegate Kaufman, the Office of the Public Defender has respectfully requested that there be an amendment to this bill that would reduce or eliminate the felony, the increase in felonies that are associated with the penalties in this bill. Have you given that any consideration?
Yes, as a matter of fact, hopefully they'll take yes for an answer, because you should have received, and Mrs. Mickey can talk about it, but you should have received from my Chief of Staff, Jason Nunez, an amendment yesterday that reduces the penalty that most people would receive to a misdemeanor, and does it based on felony versus misdemeanor, dependent upon how much money they've stolen. But the way the amendment is structured, I'm gonna pull it up. The way the amendment is structured, it says, hold on, let me just get to it. It says that, in response to their concern, it says that, it says that if aggregated value of the money or other goods or services is valued at less than $5,000, a person who violates a provision of this section is guilty of a misdemeanor, and on conviction is subject to imprisonment not exceeding 1 year or a fine not exceeding $5,000. Then it goes further and it says, if the aggregate value of the money or goods or other services provided is at least $5,000 but less than $25,000, a person who violates a provision of this section is guilty of a misdemeanor, and on conviction is subject to imprisonment not exceeding 3 years. Then the final thing is, it says, if the aggregate value of the money or other goods or services involved is $25,000 or more, a person who violates a provision of this section is guilty of a felony, and on conviction is subject to imprisonment not exceeding 10 years or a fine not exceeding $15,000 or both. So I think that this really strikes a balance, because I think when you do something this heinous, you, with all due respect to the public defender, because it's their job to be concerned about criminals and the accused, I think I have met them more than halfway, and that if you do something as heinous like this, you deserve to spend some time incarcerated. Thank you.
Thank you. Madam Chair, I do have another question, if it's okay. As you know, I'm in the home care industry and have been taking care of seniors and those with disabilities in Maryland for over almost 30 years. We'll be 30 years this year. To your panelist here, do you think that a law such as this would dissuade folks from, or family members from, pitching in and taking care of their loved ones, when we know, as you said, there are, lots of, that the need is great. There are a lot of seniors out there that are trying to take care of themselves, no matter how they're on Medicaid, they're veterans, they're all over the place, but they're hoping to have somebody that would actually come in and help them. Do you think that's, a law such as this or a bill such as this might dissuade folks from going in and taking care of their loved ones?
Is that for me or for one of the panelists?
I would put it to your panel.
I think first of all, it only dissuades corrupt family members, frankly, because I think the vast majority of the family members are honorable, decent people who love their children. I think that my friend from Legal Aid illustrated that sometimes the family members are the problem, but I defer to her for the rest of that.
I agree with the delegate. I think that it would only dissuade people who had the intention of stealing these benefits from their family members from taking care of them. I don't think it would dissuade anyone who has a genuine desire to help their family from taking care of their family.
Thank you.
Thank you. Delegate Conaway?
Thank you, Chair. Thank you, Delegate, for coming in. Such a bill. I believe I heard that there's a difference between licensed versus unlicensed.
licensed versus unlicensed assisted living facilities.
And is there a difference in the penalty?
Well, what I was referring to is, this doesn't refer to assisted living facilities. What I found in your hometown paper, Delegate Conaway, is that there was a shadow network of unlicensed assisted living facilities where they say, oh, we'll take care of you, we'll shower, we'll shave you, we'll dress you. And they don't do that. And I said that, this bill doesn't impact legitimate assisted living facilities, but advocates warn that the shadow senior care homes I discussed in my testimony function as a hidden system of exploitation, sometimes described as senior trafficking, where people, as I said, are isolated, abused, and have their benefits systematically diverted.
One last question. Would that be the Afro-American or the Baltimore Sun?
It's the Baltimore Sun.
Thank you so
I
very
can
much.
send you the article, Delegate.
Please do. Thank you.
Thank you. And last but not least, Delegate McComas.
Well, I kind of liked it the way you had it, to be honest with you. But I do think this is a very important bill, and obviously it's much needed, and I think very much needed. And sometimes you need a bit of a hammer to get people to realize that they can't do this. And so anyway, what I was going to ask is, depending on what's going to work and the amendments, I think it's an important bill. And I know that the speaker, when she was in Health and Government, she always let everybody sign on to the bill. And we didn't have that opportunity. And I think it's a good bill. And I think the committee, I feel the committee would want to put our names to it as co-sponsors, if you would be so amenable to that.
Of course I would, but that's up to Chair Bartlett. So,
Pardon?
But thank you for your kind words, Delegate McComas, and welcome back home to the Judiciary Committee where you spent 20 years.
You and I both like it, but
Yes.
don't tell the speaker.
You do know this is being recorded, Delegate, don't you?
Thank you. Thank you, Delegate. Thank you, all panelists, so much for being here. And I believe.
Can I just say one last thing?
Yes, please.
Madam Chair, I forgot to mention that your mayor, Brandon Scott, is also in favor of the legislation.
Oh, excellent. Good to know. I believe Megan Peters is signed up to testify in person. Is she here?
She changed it to virtually?
No. No, but we do have a virtual speaker, Sarah. Is Sarah available? Great. So we'll turn to that, if we may. Yes. Hello. You have 2 minutes? Or is it-
Hi.
is it- sorry. Correct. Thank you.
Hi, good afternoon, Chair Smith and members of the committee. I'm Sarah Mirsky-Mickey. I'm deputy, she is not there. I'm Sarah Mirsky-Mickey. I'm deputy director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore and all of its agencies, including HANA, which is the Jewish response to abuse, trauma, and neglect, including elder abuse. As Delegate Kaufman and my fellow panelists explained, this bill creates the criminal offense of benefits exploitation. And as was just discussed, and I'm sure most people have seen, the senior abuse expose from earlier this winter and the articles that followed around older adults and individuals with disabilities having their government benefits being taken. I wanted to just give a snippet example from HANA. We had a client who was an older adult. His adult child was taking care of him, forced him into the basement for all of the month, and abused him physically, verbally, etc. And he was only allowed out once a month for his benefits to be cashed. And for these reasons and my lack of childcare for today, we asked for a favorable report on SB 216. And I'm happy to answer any questions, especially around what all those articles we're talking about over the fall. Thank you.
Thank you. Colleagues, any questions? No. Thank you so much. Well, that concludes the testimony on House Bill 216. And I see Delegate Solomon is here. So we will now turn to House Bill 159. And is there anyone you'd like to bring up?
I actually have 2 witnesses
Online. Terrific, thank you. Thank you, even more grateful.
Delegate Jared Solomon here to present House Bill 159, the Safe Carrier Act. To my colleague's point earlier, without the 100-year mandatory minimum from year number 1, we have learned. So this is a bill that we're hearing, or I'm presenting, and you're hearing most of you for the 3rd time, hoping the 3rd time is the charm. Just very quickly, I think as many of you will recall, this stemmed from a series of really atrocious incidents in our community, but I know they've been similarly situated across the state. We have sort of entire swaths of our district where folks can't use the mailboxes. We had a number of postal carriers who were actually held up at gunpoint, and the assailants stole their arrow key, which is a device that actually unlocks the mailbox. It's also used to unlock sort of the larger boxes that you might find at an apartment complex. And so what we discovered in our work with, somebody does not like mail theft. What we discovered in our work with the Postal Service team and our local law enforcement was that, frankly, often because of limited resources at the U.S. Attorney's Office, mail theft cases are really only investigated and prosecuted if they're over often $1 million. And that's not because folks don't want to, it's just an economy of scale, right? You know, if you're going after somebody that maybe grabs a couple of pieces of mail or washes a check, or, you know, maybe grabs something here or there, A, it's hard to prosecute, B, requires a lot of resources. And what you tend to see in, you know, in the news are these sort of like big headline cases where somebody, you know, laundered $9 million or whatever it was. And then because there is no state statute, and it's also really difficult to assess a value. Like, what's the value if somebody takes a piece of your mail and then steals your identity and uses it to open a bunch of fraudulent credit cards, right? We know intrinsically what the value is in time and heartache, but it's really hard to assign a monetary value to things like that. So that was the genesis for this bill. We've worked collaboratively with our partners in the judicial proceedings, and your council in particular have just been incredible. And so last year, we worked on a compromise. I know Delegate Conaway and Delegate Tolles, who used to be on the committee, were part of it as well. And that's essentially what you see in the bill that we reintroduced today, was the compromise that was worked out and was put forward by your committee around sort of putting in 4 different categories, a category up to 15 pieces with penalties, a category of 16 pieces or more, a category around stealing an arrow key, and then possessing an arrow key with the intent to then steal mail with that arrow key. So not just possessing the arrow key, but then actually, you know, going and unlocking that, you know, central mailbox that might serve an apartment complex or whatnot. And so my understanding was the thing that sort of got a little bit of a hiccup was, I know your committee was also dealing with things around porch piracy, and there were some provisions added to the bill around facial recognition software that would be used potentially in piracy issues, and that was not part of what we had sort of talked about in the mail theft piece of it. So again, this bill as introduced is just sort of the provisions around the mail theft piece that were negotiated last year, and we're hoping again this year we can get things through, and 3rd time's a charm. So with that, again, our 2 witnesses here have a ton of expertise on this and happy to take questions and hope for a favorable report. Thank you.
Would you prefer to take questions now, or would you prefer to take questions with the panel?
With the panelists.
Okay.
It's one of the chief inspectors from the USPS and one of our state's attorney.
Terrific. Could we put the panelists on the screen?
It's Steve Sultan and Robert Hill.
Steve Sultan, Robert Hill are the 2. Okay, great.
Perfect. Thank you.
Mr. Sultan, oh, there you are. Perfect. Mr. Sultan, if you'd like to begin. And you are muted.
Thank you. So Chairwoman and members, thank you for the opportunity to speak with you today. I'm Stephen Sultan. I'm the United States Postal Inspector and Acting Chief Counsel for the United States Postal Inspection Service. The Inspection Service is the federal law enforcement and security arm of the United States Postal Service. Our agency works diligently to enforce criminal laws to protect the Postal Service employees, customers, and our nation's mail stream. Unfortunately, over the past few years, mail theft and robberies of postal carriers have risen dramatically, In the past, this criminal activity was predominantly committed by lone actors in small informal groups. Now it's become common for large, organized criminal groups to be involved with these crimes. And many of these robberies are of carriers for their postal keys, which, as you heard, were sometimes called arrow keys. These keys permit access to collection boxes, outdoor parcel lockers, cluster box units, and apartment panels in a given geographic area. Once in possession of these keys, these criminals are able to steal U.S. mail from these receptacles. This mail is then used to commit financial crimes with often devastating financial impacts to the victims. The Postal Service has taken significant steps to address this increase in postal crime. We're upgrading collection boxes with high security features, including electronic components. We're raising awareness through public education, messaging, and training our employees and law enforcement partners. And we've stepped up our enforcement of the laws that protect our employees and the nation's mail by collaborating with prosecutors and other law enforcement agencies at the federal, state, and local levels. This legislation would enhance this enforcement. It would supplement and not replace or usurp federal laws and would further the collaboration that's already occurring. Postal inspectors are proud to work diligently alongside local Maryland law enforcement and prosecutors to protect Maryland Postal Service employees and keep Maryland postal customers' mail safe. I recognize that your constituents depend on the Postal Service for safe and reliable transmittal of mail, and this bill would enhance our ability to carry out this mission. Thank you.
Thank you very much. Is Robert Hill available? He's not. Is Mr. Richard? Okay, we could turn to Mr. Richards. Thank you.
Well, thank you, Madam Chair, members of the committee. For the record, my name is Evan Richards. I'm the head of government community relations for the Maryland Bankers Association. You have our written testimony. Of course, we're in strong support of House Bill 159, so I'll be brief. As Mr. Sultan mentioned, when mail is stolen, it is stolen to conduct financial crimes. So it's a check fraud, which is a huge issue that our membership is still dealing with. It's involving when criminals steal the checks and either they're creating counterfeit checks or they're chemically washing these checks and writing in new payees and amounts. And bank customers are losing tens of thousands of dollars, if not more. These checks are important to customers, especially those elderly customers who still prefer to pay via check, or small businesses who rely on checks to meet their daily obligations. We support these efforts to help combat these crimes. But again, we're in strong support of House Bill 159. I'm happy to answer any questions.
All right, thank you. Are there any questions for our witnesses, for the panel? Mr. Delegate Conley.
Thank you, Chair. Thank you, Delegate, for coming in and presenting your bill. To Mr. Sultan, if a arrow key is stolen, is that on a high enough level to trigger an investigation, or how would that work?
Anytime an arrow key is stolen or reported missing, then we would investigate it to determine, what happened, what the circumstances are, and what kind of concerns there are with that particular arrow key being missing.
And is that potentially a federal fraud, a federal charge?
It could potentially be a federal charge, but as the delegate had mentioned, there are thresholds at the federal level, so it really depends on what is what's found. Regardless of how much is lost or stolen or whatever, we would do an investigation just to make sure that our security and our systems are in place.
Thank you so very much.
Any other questions? All right, any closing comments that you'd like to make, Mr. Sponsor?
Just that the bill that this was based off of, again, from last year, passed unanimously out of the House. So just urge a favorable report. Thank you, Mr. Chair, Madam Chair.
Thank you very much. That concludes the hearing for House Bill 159. All right, we're going to move on to House Bill 444, excuse me, House Bill 444. Yep. And I understand that the sponsors panel is, of course, Delegate Williams, Comptroller Brooke Learman, Amy Frimpong, Stephanie Wolf, and Noreen Shaw, who will be coming in virtually. Welcome, Madam Comptroller.
Thank you.
I knew there was a new chair, but I didn't know that it was, I thought he looked different.
We're trying out kind of revolving chairs today.
Yeah.
So we're good. And Madam Sponsor, whenever you are ready.
Okay. Can you hear me?
Yes,
Yep,
we
okay.
can.
All right, good afternoon, Chair and members of the House Judiciary Committee. I'm Delegate Nicole Williams testifying in favor of House Bill 444, also known as the Public Safety Immigration Enforcement Agreement Prohibition. This bill would prohibit any agent of this state or unit of local government from entering into certain voluntary immigration enforcement agreements with the federal government, commonly known as 287G agreements. The members of this committee will recognize this bill from last session. We have seen the abuses, including the murder of American citizens by ICE across our state and across our country since last year. ICE is actively creating chaos, confusion, discord, and violence within our communities, and having an obligation to protect Maryland families from these unconstitutional and immoral attacks on our values and our bodies. At the start of 2025, we had 3 counties here in the state of Maryland that had active 287G agreements: Hartford, Cecil, and Frederick County. Since then, we have 6 more counties that have now entered into these agreements, including Carroll, Washington, Garrett, St. Mary's, Allegheny, and as of Friday, Wacomico. This is a tripling of the counties with these active agreements in less than a year, despite what we're seeing all across the country in cities like Minneapolis, Chicago, Boston, and even right here in the state of Maryland. And the trend is very clear. Now is the time to ban 287G agreements. Officials who assign these agreements claim that they are a means of enhancing public safety, but that's false. These agreements drain taxpayer dollars from the real work of local law enforcement. And while ICE does provide training, equipment, and some oversight, it offers no reimbursement for the staff and overtime required by these additional responsibilities. In a tough budget year for our state and local jurisdictions, these funds can be better used to enhance public safety rather than participating in one-way arrangements with ICE, who have shown to openly ignore the constitutional rights of American citizens. Ending these programs in our state is not without precedent. Anne Arundel County terminated its existing contract in 2019 because the 287G program, quote unquote, had no meaningful impact on keeping county residents and visitors safe, nor does it assist the county's efforts to identify and arrest violent criminals. Other states across the country have passed legislation effectively ending 287G programs, including California, Washington, Illinois, and Colorado. It is time for Maryland to now follow suit and to keep our residents safe. And ending the 287G programs reflect our values as Marylanders and protect our communities, families from this hateful agenda. That's pretty much it. I'll end it there. Thank you, Mr. Chair.
And who's going next, Madam Comptroller?
Thank you, Mr. Chair. Members of the committee, I'm Brooke Learman, the Comptroller of Maryland, and I'm here today in support of HB 444. Now, Maryland is home to a large and diverse population, and our immigrant population plays an essential role in the social and economic life of our state. Immigrants represent nearly 17% of Maryland's population and more than 21% of our workforce. These residents are deeply integrated into our communities, workplaces, and local economies. They're our neighbors and our friends. Policies and enforcement practices that create fear and uncertainty among immigrant communities can have consequences that extend beyond the individuals directly affected. When families are reluctant to go to work, attend school, or engage in daily economic activity due to fear of immigration enforcement, those impacts are felt across our state, including by employers, by local governments, and by essential service providers. So I want to highlight some of the economic implications of these dynamics. In April 2024, our office released a report examining the role of international immigration in Maryland's economy. That analysis found that immigrants make substantial contributions to the state's workforce, tax base, and overall economic growth.
Immigrants account for more than 1/5 of Maryland's civilian labor force and are employed across a wide range of industries that are critical to our economy, including agriculture and food processing, healthcare, science and technology, education, and more. For example, immigrants make up approximately 23% of Maryland's STEM workforce and 23% of registered nurses statewide. The Maryland Hospital Association produced a study that showed a projected 20% shortfall of nurses versus the demand by 2035. In other words, these are essential workers in our economy. We need them. Immigrant communities also greatly contribute to our state's revenue through taxes and spending. The American Immigration Council data show that in Maryland in 2023, immigrants paid $15.8 billion in federal, state, and local taxes and had a total spending power of $39.5 billion. So keep in mind that numerous studies have now demonstrated that when immigration enforcement is very salient, immigrants in the U.S. pull back on their spending because they're not going out for into public for leisure or for shopping purposes. If immigrant communities believe that local law enforcement is the same as immigration and custom enforcement officers, their consumer spending will decrease. In Orange County, for instance, businesses lost nearly $59 million in economic output over just 8 weeks following immigration enforcement there. So it's just important to recognize that policies that promote stability and trust within immigrant communities also help protect and buoy Maryland's economy and increase our economic resilience. Ensuring that state and local law enforcement agencies are not placed in roles that undermine public trust supports community safety, workforce participation, and economic continuity. For these reasons, I respectfully urge the committee to issue a favorable report. Thank you very much.
Thank you, Madam Comptroller. And as a courtesy, we did give you the 3 minutes. We're going to stick with 2 minutes for the rest of our witnesses.
Good afternoon. My name is Ama Frimpong. I'm the legal director at CASA, where I oversee the delivery of civil legal services across a wide range of matters, including immigration. In 2025, my legal team provided legal assistance to more than 2,500 Maryland residents with diverse immigration statuses, as well as U.S. citizens. Through our engagement with Maryland residents and their families, we witnessed the harm that ICE is unleashing on our communities. In 2025 alone, CASA responded to 567 ICE detentions in Maryland. From smashing the windows of harmless mothers to shooting unarmed workers, these dangerous tactics have caused fear and terror in our communities. 287G undermines public safety and impedes access to justice. By turning local officers into ICE agents, 287G has destroyed trust between police and immigrant communities. Community members are afraid to report crimes, come forward as witnesses, or exercise their rights in courts. This lessens public safety for everyone. 287G serves a mass detention and deportation effort that is lawless and disregards basic individual rights. This includes violations of due process rights and violations of rights against unlawful seizures. In 2025, there were 184 habeas lawsuits filed against ICE here in Maryland, challenging unlawful detentions. In 2024, that number was only 2. The impact of 287G spills over from the jails in which on paper it is supposed to function. As one example, a father who was pulled over on the road for a simple traffic violation was handed over to ICE by Frederick County law enforcement officers in February 2025. He had resided in this country for 22 years, had recently lost his child to cancer, and had no criminal history. Ending 287G is a necessary step that gets us closer to rebuilding trust within our community. Thank you for your time.
Good afternoon, Mr. Chair, members of the committee. My name is Stephanie Wolf. I'm the Director of Immigration Services at the Maryland Office of the Public Defender. And we respectfully urge this committee to issue a favorable report on House Bill 444 to end 287G agreements in Maryland. These agreements, which obligate local officials to do work on behalf of ICE, undermine due process and make innocence irrelevant. They require local jail officials to screen, interrogate, investigate, process, detain, transfer to ICE custody any person that ICE suspects of being deportable under civil immigration law. There are no exceptions for the factually innocent, the wrongfully arrested, or those who have committed only minor offenses and pose no risk to public safety. Not only does 287G not exempt those least culpable people, it actually targets them, because the only people that 287G agreements in Maryland impact are the people being released from a local detention center. And that is not where you generally end up if you are convicted of a serious violent crime. That's why the majority of people impacted by these agreements in Maryland do not have convictions, and almost none of them have convictions for serious violent crimes. Over 7 years of 287G in Maryland, for every one detainer on someone with a serious violent conviction, there were 115 detainers placed on someone with no conviction at all. National data shows the same pattern. And 287G agreements do not protect our communities by reducing ICE arrests outside the jail. If they did, many of the people asking you to pass this bill would probably think differently about it. But the fact is that the opposite is true. 287G allows ICE to use our legal system as a force multiplier, freeing up their agents, their detention space, and their resources to make even more arrests on our streets. We urge a favorable report. Thank you.
Thank you. I believe we have one virtual on this first panel, Noreen Shaw.
Thank you, Delegate. Can you hear me?
Yes.
We can, thank you.
My name is Noreen Shaw, and I'm the Director of Immigration Policy for the National ACLU. More than ever before, when local agencies enlist in the 287G program, they enlist in a dangerous, reckless, and increasingly lawless ICE machine. That machine is so dangerous that just days ago, we saw federal agents beat and shoot to death Alex Preddy. We saw them take 5-year-old Liam, a boy, hold him by his little Spider-Man backpack, and we saw a photo of him staring ahead in fear as his world fell apart. Cardinal Tobin of New Jersey just said in a prayer service regarding ICE, "How will you say no to violence? One way that we say no is that we mourn. We do not celebrate death, and we do not pretend that it does not happen." I urge you to consider the moral gravity of this moment. Should Maryland's law enforcement join ICE, an agency that's been turned into this violent and reckless apparatus, or should they prioritize the safety and trust of Maryland residents? Should Maryland agencies join ICE, which wrongfully deported Maryland dad Kilmar Abrego Garcia to a torture prison and risk lawsuits that could cost municipalities millions in damages? Should counties like Frederick continue a program that led to a show-me-your-paper style policing force, even when 287G was confined to the jail, resulting in the illegal detention of a grandmother driving with her grandkids and a lawsuit? Around the country, as you have heard, hundreds of cities and states have said no to being part of the 287G program. Maryland should join Maine, Delaware, New Jersey, Connecticut, Illinois, Washington, Oregon, and California in prohibiting 287G or collusion more generally. These states have said no to treating people as suspect based on their color of their skin, no to racial profiling. That means police pull people over for low-level offenses and arrest them simply to feed the ICE machine. Thank you very much.
Thank you, Ms. Shaw. All right, are there questions for this panel? And I see there are several. I'll start to my left. Delegate Moreno.
All right, I have a couple questions for the ACLU. As related to Maryland, the ACLU has previously litigated against Sheriff Chuck Jenkins in Frederick County, alleging racial profiling related to immigration enforcement under 287G program. Could you talk to the committee through the key facts and evidence that form the basis of that lawsuit and explain how the court ultimately addressed and resolved the issues presented?
Thank you for the question, Delegate Moreno, and I'll also refer you to our written testimony from the ACLU of Maryland. What happened in the lawsuit was that a woman, a grandmother who I just mentioned, Sarah Madrano, she was driving with her daughter and her grandchildren when she was pulled over. Law enforcement officer said she was being pulled over for a broken taillight. In fact, that broken taillight was working just fine. They interrogated her about her immigration status, and then they detained her illegally, making her believe that she would be deported from her family. And in Madrano versus Jenkins, the court ruled in favor of her, and ultimately there was a settlement and a $25,000 award in damages and an apology from the Frederick County Sheriff. So what can we learn from this lawsuit? One thing we can learn is that even when we talk about the 287G program as something that is confined to the jails, as it would be going forward in the state of Maryland, it does not stay confined to the jails. In fact, the 2021 Washington Post review of participation in 287G found that counties that participate in it, there's more people who are arrested for low-level offenses, and that was at a time when only the jail model of the program was in force. So we need to be worried about the 287G program. We need to be worried that it won't stay confined to what ICE or what people are told it will stay confined to.
Thank you. Could I follow up with a second question?
Yes, ma'am.
Thank you. As related to patterns of misconduct in 287G jurisdictions, drawing on the ACLU's national litigation experience, could you describe the most common patterns or trends of misconduct you have observed in jurisdictions with 287G agreements? And related to that, are there particular types of abuses or rights violations that emerge repeatedly? And what factors tend to contribute to those recurring issues?
Thank you so much for the question, Delegate. One of the big problems with the 287G program is that even when it is confined to the jail environment, what it means is that local law enforcement are more likely to engage in racial profiling. And I said a little bit about this in my testimony just now. Essentially what it means is that if I'm driving down the road, a law enforcement officer sees me, they may pull me over for a broken taillight or for some kind of low-level offense for which they can book me into local custody, not because they think that I pose a specific danger to public safety based on my conduct and the way that I am driving, but because they want to feed the ICE machine. They want to bring people in to the deportation pipeline. Now, racial profiling, we know from our experiences all over the country, is extremely difficult to prove. But what we know is that in Maryland counties, such as Frederick, where 287G has been in place, there's been racially disparate policing practices. Black people are far more likely to be pulled over than non-Black people. Brown people, people Latino heritage in Frederick County experience racial profiling. They've reported it again and again for years and years. And the impact on that in public safety is also clear. When people are afraid that a routine interaction with law enforcement could lead them to be separated from their children, from their spouses, from their communities, they are far less likely to go to law enforcement and report crimes, to report serious matters that need to be investigated, to seek help, even to dial 911. That makes all of us much less safe.
Thank you.
Thank you, Delegate. And that's, you good?
Yeah, I'm good.
All right, Delegate Aragon.
Thank you, Mr. Chair. Thank you for being here today, everyone. You had mentioned that Anne Arundel County had canceled their 287G agreement. Do you know in which counties in Maryland we've seen ICE-involved shootings? Sponsor? No?
I mean, there was the shooting in Glen Burnie.
In Anne Arundel County, that's correct, after they had canceled the 287G. In fact, in the counties where 287G exists, we've not seen that. In addition, when 287G exists, we've got significantly lower risks of collateral arrests. Were you aware of that? And also community level arresting is a lot lower. So are you prepared to push forward a bill that will have President Trump tomorrow sending ICE teams in here to collect folks from the community versus the system we have now in many counties where they simply pick them up through the jail model, where there's no collateral arrests, where grandma and grandpa aren't home also and also getting arrested and then deported? Are you prepared individually or really as a body to move policy forward that will likely lead to more events like what happened in Anne Arundel County? And there will be blood on the hands of the people that move this when folks die because there's no longer a jail model in place. So are you ready to do that?
Well, first of all, ICE shouldn't be randomly engaging in shooting individuals so that there will be blood.
That is not what occurred. Let's be careful.
So that there will be blood in the streets. But I will say we have seen large ICE activities in counties that do not have these agreements. I represent part of Prince George's County. We had an incident several months ago in my own district where ICE was literally apprehending someone in the middle of broad daylight during morning rush hour in the middle of traffic near an elementary school.
Yes, correct. There will be more of that because your county
But
does
that
not
has nothing
have.
to do with these
It does not have
agreements.
287G, and that is why they are going into your community. You will be expanding that statewide. So if that is what you want, that is what you will get. And you will hear from, I'm sure, the administration post haste at the change in policy ICE will be administering to our state because of your bill alone.
Are you prepared to condemn ICE when they engage in reckless activities that is in violation of what they've been trained to do?
When I see it, I'll let you know.
I'm sorry, did you want to add something, sir?
If I could, just to address the idea that there is lower enforcement on the street in counties with 287G agreements, that is not what the data shows. If you would reference the chart on page 4 of the Office of the Public Defender's written testimony, you'll see that across the country, it is true that the more 287G agreements there are in a state, the more ICE arrests there are overall, and also the more community ICE arrests that there are overall, meaning arrests that took place outside the jail. And that same pattern holds true in Maryland. In Frederick County, which does have a 287G agreement, obviously, there were, I believe, 55 street arrests this year versus 38 in Howard County, even though Howard County has a higher population and much less cooperative policy. So it's simply not the case that 287G agreements increase street enforcement.
Ma'am, Howard County may have a higher population broadly, but they do not have a higher illegal immigration population. So let's make sure we're actually talking about the accurate data here. That's not reflective, but thank you.
Thank you. Delegate Taylor.
Thank you, Mr. Chair. Trying to reel it back to across the country, actually, several 287G programs have been terminated or curtailed by the Department of Justice. There have been investigations, civil rights lawsuits. Can you speak to the types of legal liability local governments face when participating in these programs? And maybe, Ms. Shaw, that might be best directed at you, for you to answer.
Thank you so much for the question, Delegate. We know that municipalities around the country have faced enormous liability for doing the bidding of ICE. They have had to pay out damages and lawsuits. New York City recently had to pay $92.5 million in a settlement with people that it had held on ICE detainers, on top of an earlier $14 million settlement paid by the Los Angeles County Sheriff's Department. So we're talking about huge numbers, and the reality for a lot of smaller towns and counties is that they just cannot handle that kind of risk of liability. The federal government isn't going to fully protect municipalities that engage. We know that although there's provisions in the Immigration and Nationality Act that would provide law enforcement officials acting pursuant to a 287G agreement, basically that they would be considered to be acting under color of federal law, that doesn't fully immunize them from suit, and it certainly doesn't immunize the counties, the municipalities that would be left holding the bag. In fact, we know that those municipalities face that real risk, and that is one reason why when I speak with law enforcement officials around the country, a lot of law enforcement leaders say we do not want we do not want to take part in this program. On the other hand, some say, well, we're just going to rely on the judgment of ICE. If ICE tells us to hold somebody, we can rely on them and their judgment. And unfortunately, that's not the case. We know that even here in Maryland, ICE has continued to hold people, a U.S. citizen, a young woman, even after her family showed a birth certificate and other documentation. And we know from lawsuits that the ACLU has brought around the country that U.S. citizens have been wrongfully detained, and ICE has even refused to acknowledge those mistakes after it's been revealed. And so we can't simply rely on the judgment of ICE. Local law enforcement that do so could be held liable for Fourth Amendment violations.
Thank you, and thank you, Delegate Taylor. Was anything else, Delegate Taylor? Before we move to the next delegate, and I'll come back around to Delegate Simpson, I know we have the comptroller here, and we don't want to hold you all day, so I want to make sure you're okay. But I do want to ask you, have we seen any indications in Maryland of the impact of ICE on our economy? Are there any specific, either extrinsic or intrinsic indicators that you might want to speak about?
Sure. No, I appreciate the question. I think at this point, it's too soon for us to, we haven't done any economic modeling on areas where there's been an increase in ICE activity and isolated that to look at sales tax activity. That's certainly something that we can look at in the future or try to look at in the future. But there have been numerous studies across the country over the past year. I was just reviewing a report from the Brookings Institute on the impact of declining immigrant populations and the challenges that that's going to present for our employers, for our workforce, and for our revenues in the coming year. So I think there's, many, many reasons to be concerned about decreasing immigrant populations and instilling fear in immigrant populations so that they retreat to their homes rather than involve themselves in economic activity.
Are there any other questions specifically for the comptroller? All right. Okay, we've got two. Okay. I'll go here to Delegate Mangione.
Thank you, Mr. Chairman. And you took a little bit of my question there, and thank you, Madam Comptroller, for being here. And I kind of just want to make sure I'm understanding your report correctly, because you say that immigrants are boosting the economy, which I think we all can agree with.
Yep.
But your data, I would assume, largely, largely reflects legal immigrants, correct?
Well, the data is on immigrants, period. We don't have a way in the data of distinguishing the number of folks who are undocumented versus not. Some percentage of the people who are in these jobs are undocumented, but we don't have a way of knowing who those people are.
Okay, because I guess then bringing it back to 287G, it really applies to those who are undocumented individuals, I believe for the most part already in police custody for committing a violation. So in terms of economic benefits, I mean, is it really coming from the people that law enforcement's targeting? I would have to say no, and according to your answer to the chair's point, you do not have data. So you're basically saying that by working together with law enforcement to make our communities safer, it's going to hurt our economy.
No, that's not what this report says. So the report that we produced talks about the importance of immigrants in our economy. I think, if you've read it overall, and to answer your first question, it does not distinguish, because we have no way of distinguishing in the Office of the Comptroller the exact percentage of immigrants who are undocumented versus not. But my testimony is based on our understanding of immigrant behavior overall and as consumers. And certainly if you look at, and again, there's no way to delineate between immigrant consumers who are undocumented versus immigrant consumers who are documented, right? When they're going in the store and spending money and paying sales tax, they're paying the same sales tax whether they're documented or not. And so when you look at studies across the country, particularly I thought one from Orange County was particularly well documented that shows when there's an increase in ICE activity in a particular neighborhood, they see decreasing economic output. And over 8 weeks in Orange County from the summer, they saw $59 million decrease in economic output in the area around where there was an increase in ICE activity. So my testimony is that when there is increased fear of law enforcement, because law enforcement may be working in partnership with ICE, that law enforcement, other folks are talking about what that means for public safety, and I'm saying there is also an economic component. There is an economic component because immigrants may end up staying home and not spending money, may say we can't work anymore, we can't go do these jobs anymore because there is this increase in enforcement. And that may, at some point, result in lower revenues, lower economic activity overall.
And if I can
Does that help?
One last thing, and I do appreciate your answer. Yeah. There is a massive difference between, and you're saying the economic impact you're saying is not being differentiated in the study between legal and illegal. I'm simply just want to make the point that when you say immigrants, you're not making a difference between those. Here, legally and illegally. So I guess why would a legal immigrant be worried about immigration enforcement?
I mean,
So I just wanted on
really?
the record.
I mean, I feel like basically every news story for the past, 12 months would make the case for why legal immigrants and documented immigrants would be worried about interacting with ICE. I don't know
But
that
you're
I
sitting
need
here
to-
saying they're under a threat by ICE and being.
Yes.
Yeah, so that's where we
I mean,
differentiate.
to U.S. citizens, I mean, many people are under threat by ICE right now. So yes, I think that legal documented immigrants also have a reasonable fear of interacting with immigration and customs enforcement.
From an economic standpoint, that clearly would be an opinion-based statement. As you already said, you don't
I am
have
here to
any
provide my opinion based on the data that we have seen and the data that I know.
And the
Yes.
okay, last thing I'm saying, I appreciate you being here, is that whole presentation in the beginning never differentiated between legal and illegal, and that's
No,
where I
I'm
think
talking about immigrants overall and their fear and economic activity. Yep, thank you, Delegate.
Thank you, Delegate.
If I may jump in to
Yes, go right
clarify a
ahead.
very important point, thank you so much. I believe that, there's been a, kind of a gross misstatement of who is captured under the 287G program that I think is important to correct for the record. I believe the delegate stated it as undocumented immigrants who have committed crimes. Two very important things here, right? 287G does not capture or focus only on undocumented immigrants. We first need to understand that in the past year, there has been a deliberate effort to de-document individuals who were in this country lawfully. Around the country, that's been 1.5 million people who were here on temporary protected status, DACA, parole, right, asylum status. In Maryland, that's tens of thousands or hundreds of thousands of people who have lost status that they had. So those are now individuals who were lawfully present, and the administration has now widened the scope of who is considered undocumented. That's one. And two, it's important to remember, 287G does not capture people who have committed criminal offenses. It's individuals who have been arrested and accused of committing offenses. Just because someone is charged with a criminal offense does not mean that they are guilty of that offense. It's very important, particularly in the Black and brown communities where folks are overly policed, overly arrested, overly charged. It's very important to not equate an accusation with a conviction. So I just think it's very important to understand the way that this program works so that we are not misstating for the record. Thank you. Thanks.
illegal alien citizens. So I just want to rebut that.
Absolutely, except that the lines are completely blurred. Over the past year, folks who are documented have had their statuses revoked, and folks who are still here lawfully are being captured, arrested, disappeared by the government. So it is, again, very important not to try to make it as black and white as you are making it seem, because that's just not the case.
Thank you, Delegate, and thank you. Delegate Cardin.
Thank you, Mr. Chair. And I do have one other question, but I'll hold off on that one. I'm just going to talk to the comptroller. It's great to see you here. And I don't want you to toot your horn too much, but would you consider yourself one of the foremost experts on fiduciary responsibilities in the state and the fiscal expert for the state and its finances?
So. I've learned a lot, I'll tell you that,
Okay. So you did
I have a great team that helps me be
You did a very good job.
expert.
Thank you. You did a very good job articulating the fact that there's nearly $40 billion of generated economic activity from immigrants, whether they are undocumented, documented, we can argue about that. But and there's possibly as much as $15.8 billion in tax and other fee revenues coming from this community.
Yep.
Is that was the numbers I think you gave, right?
Yes.
Okay.
Yes.
So would you, as an expert here, be able to say or agree that perhaps when we talk about affordability, which is a major issue for us this year, for all Marylanders, not just for those who are perhaps immigrants, but for all Marylanders, affordability, would affordability be impacted perhaps in the area of affording landscaping services or nursing services or assisted care living services for all of us who are seeking those services, as well as would it be difficult for those companies to be able to find employees to be able to service them? Can you enlighten us on that?
Yeah, absolutely. As we're trying to create a more affordable Maryland, if we're trying to create a more affordable country, I would say a key thing not to do would be to drive away our workforce. And certainly that holds true here in the state of Maryland. If we have fewer workers, and because we have fewer immigrants, and keep in mind the immigrant population overall is younger than the native-born population, so that is part of the reason that they're a greater percentage of our workforce, or that they are such a large percentage of our workforce, we will see prices rise. I mean, it's as easy as that, whether it's for nursing, whether it's buying a home, construction on our roads, our bridges, everything that will contribute to rising prices in almost every category. Thanks.
Thank you, Madam Comptroller. Did anyone else have a question specifically for the Comptroller? All right, thank you, Madam Comptroller.
Thank
we
you all.
appreciate you
I
coming
appreciate it.
before us
Thanks.
today. Okay, we'll go over to Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Delegate and panel, for coming in to testify. 2 questions. Is Homeland Security active now?
Is
Homeland Security?
Are they active now?
Yes.
Delegate, are you referring specifically to Homeland Security generally or ICE specifically?
No, Homeland Security generally in the country.
I mean, it's a government agency that I
Yeah,
believe
well,
is still
I'm
in
looking at it,
operation.
says they are active, so. And my second question is, are we talking about people that have detainers but have gotten captured in low-level offenses? Or are we talking about people that do not have detainers and just getting randomly picked up on walking down the street? What's the percentage on that?
So the jail-based models that Maryland has in place now they impact people who get arrested.
Yes.
Not necessarily people who are guilty, not necessarily people who have been lawfully arrested, just anyone who is booked into the jail. We do not have the task force model at this point in Maryland because it arguably would be illegal under our current law. The task force model would allow police on the street to make an arrest solely for an immigration purpose. But what you heard Ms. Shaw say earlier, and what I think is very important, is that even the jail-based models do not stay confined to the jail, because if you have an interaction with the police and that interaction, for whatever reason, leads to an arrest, no matter what happens next, the prosecutors could say, oh, I'm so sorry, we got the wrong person, and release you tomorrow. You could be released by the commissioner pending your trial date on a minor driving without a license charge. You could go before a jury of your peers and be found not guilty, and none of that will matter to the outcome that you will be handed over to ICE if ICE wants you. And so, no, we are not targeting people who have been convicted of crimes. We're targeting anyone who has been arrested, no matter what happens.
So it's not like when you're driving your car and your tags are suspended and all of a sudden the officer's screen blinks red, so he knows that something's wrong with the vehicle. They might not even know that you're that you don't have really an infraction that's that great. Is that what you're saying?
So in the context of a traffic stop?
Well, I'm just saying, if you get taken to jail and you get ready to get released, does something come up on the screen to say there's a detainer on this person, or they just say, well, I don't know if it's a detainer or not, so just go ahead?
Yes, that's a great question. Thank you for asking. When you are booked into a jail, you are fingerprinted. Your fingerprints get sent to a national federal database, which is linked to DHS. And so that when you are fingerprinted and your prints go into NCIC, there will be a flag to DHS. If they want to place a detainer on you, they get a notice and they place the detainer. And so yes, there is, in a sense, there is sort of the blinking screen. But it comes from ICE sending the detainer to the detention center.
Thank you so very much.
Thank you.
And can we be clear, that detainer is if there has been a conviction of some type?
No.
Okay, so that detainer could be an administrative flag.
It is an administrative detainer that's issued by ICE based on their desire to investigate the person for a civil immigration violation.
Thank you. Delegate McComas.
Chair. I come from a county where we've had actually 3 people that I'm aware of that have died due to problems. And it wasn't necessarily the fact that ICE was or wasn't there, but 2 of them had prior murders. And thank God they didn't kill anybody while they were waiting to prosecute them. But what I'm saying is, don't you think that a 287G program, Maryland is America in miniature. Each county is very different. And so why don't we let the counties and the municipalities decide whether they want ICE or their detention centers to decide whether they want the program? I mean, that's the fair way to do things. And now certainly Montgomery, Prince George's, and Baltimore City, they don't want ICE. They don't want to ever see him come in the city or the counties. Harford County is very happy with ICE. The community is happy with ICE. I think Frederick County is very happy with ICE. And some of the Eastern Shore counties. Why don't we let the locals decide whether they want it? And most of them, if they like their sheriff and they have the 287G and they think it's working and they want to do it, let them do it. The other thing is everybody's got their own spin on which side of this. I mean, it's a national issue. It's up in Minnesota. We are not Minnesota. We are not Minneapolis. Okay, and I know we have Trump derangement syndrome. I get all of this, okay? But the problem is everybody's got their own pitch. And maybe what we ought to do is get some independent analysis, because I don't believe either side anymore. But I do think that if the community wants ICE and they want it, then they ought to be able to have it and let their sheriff have it. And if the sheriff is abusing it, hey, they're gonna get sued and that'll be the end of the problem. And I think I mean, I assume you don't want it, okay, because you got the votes for it. I mean, I'm not stupid, I counted 81 people. But the point is, are you really helping everybody? I don't think so. You're not representing one Maryland.
Delegate McComas, I just want you to get to a question.
So?
All right, thank you.
Mario, is that so?
Thank you. All right, I missed my good friend to my left, Delegate Woods.
Thank you, Sir Chair. And thank you all for the wonderful, accurate, and relevant presentations that you've made today. My question, I actually have 2 questions. Both of them are for Amma. And I'd like if you could talk more specifically. We've heard a lot of impact statements, but what impact do these enforcement partnerships have on the victim's willingness to report crimes or corporate with police, especially in the cases of issues like domestic violence and sexual assault? That's the first question.
Sure. Thank you so much for that question. In our work as legal service providers, we interact quite a lot with individuals who are survivors of crimes, including very horrific crimes. And the fear is real, right? I believe that there is a study that says that I believe 60% of immigrants who are aware of local law enforcement collaboration with ICE are less likely than their counterparts to report crimes. In our experience over the past year, that percentage is actually closer to 100%, right? And we partner a lot with organizations like the Tahirih Justice Center, which works exclusively with immigrant survivors of crime. And we're all seeing the same thing. Individuals are afraid to report crimes to ICE because they believe that they will, they are afraid to report crimes to local law enforcement because they believe that they would be turned over to ICE. And this is true even in counties that don't have 287G agreements, right? That fear spills out of those counties and into our whole state.
Thank you. May I ask a second question?
Yes, you may.
My second question is this: what's the impact that you're seeing directly on the community, on undocumented immigrants, those with protected status, and naturalized citizens?
That's a great question as well. Look, at this point in time, we are seeing, you know, what I spoke to not too long ago, right, about the fact that even individuals who are here lawfully and who have been here lawfully for years are terrified. We're seeing a deliberate effort to strip people of their lawful protections that they had. We are seeing a deliberate effort to terminate people's pending applications for lawful status that they have. So individuals with pending asylum applications are now suddenly being told the federal government is no longer going to process asylum applications. We're seeing U.S. citizens are walking around carrying their passports because they understand that it does not matter your immigration status as long as you look like you might be here unlawfully, and what that means is as long as you look like you are brown, right, and also Black, you are a target for this administration. So our community is absolutely terrified, and we are seeing, you know, the delegate spoke not too long ago about blood on people's hands. I want to be absolutely clear. There is blood on the hands of any government that at this point in time is collaborating with ICE. We are seeing record deaths in ICE custody. 287G feeds directly into ICE custody. We're seeing people die. We're seeing people being tortured. At this point, every single community member that we work with at CASA can tell you a story of their loved one who has been violently arrested by ICE. They can tell you the story about people who are in horrendous conditions. So our community is terrified. People are not going to work. People are not going to school. They're not going to the hospital. They are missing their court dates. Employers are taking advantage of them, right? The fear is real, the terror is real, and it is having a great impact, not just on individuals who are undocumented, but those who are documented, including our citizenship population.
Thank you so much. Thank you, Mr. Chair.
Thank you. We're going to go to the last two questions for this panel. Okay, the last three questions for this panel. I'll go with Delegate Congolo.
Mr. Chair, and thank you all for providing some information today. However, I still have some questions.
And Delegate, just 1 second.
Sure.
I would just ask that we maintain decorum in the room. I see that there is I'm not sure if that's a camera or what's being held up. Just ask you to put that down. Everything is recorded, so it's all available. Thank you. All right, Delegate Congolo.
Okay, thank you. And I was glad to hear the delegate mention the victim and mention, I heard also the Black and brown community and the fear and the torment. But I think the victim that we're forgetting here is Takara Thompson, okay, out of Prince George's County, 19 years old, same age as my daughter. Her birth date is the same as mine. This case was near and dear to me. Not only did she die in Prince George's, that she was victimized, but she was found in Anne Arundel County. So Ms. Shaw, in her testimony, she stated, and I'm not going to say it was verbatim, but she did mention that, there are cases of undocumented individuals who are committing crimes, okay? So I want us to focus on that victim, okay? This young lady didn't even have a chance to live. And this person who killed her, they were out, they had already committed a crime. So these cases exist. So my question is that can we look at both sides here? I hear that you're talking about certain communities, certain people who are victims here, but we also have victims who are losing their lives. This young Black woman didn't deserve to die. So my question is if we know that this is happening, if you're going to get rid of 287G, how are we going to identify those people who are here, undocumented, who are committing serious crimes? We don't need another DECARA. So what is your alternative to that?
So really then the police should be doing their policing and investigating missing persons reports and really investigating if there's an allegation of a homicide, doing the regular policing work to basically close that case in the case of a homicide. I don't think that what the activities of our local law enforcement, if they receive a report, they don't, if a report of a young girl is missing, they're going to treat that case regardless of who the alleged perpetrator is. And that's what they do in counties where these agreements do not exist. They just engage in natural law enforcement and they close those cases.
May I ask a follow-up question, Mr. Chair?
You may.
Okay, so my
Question.
Okay, yes, question. So I hear you. You say that, the police are to do their job, sure. But how do we handle that undocumented individual who is here after committing a crime?
The person would be arrested. They would have their day in court. They would be, the court would hear both sides of the case. And if the evidence shows that they're guilty, they will be found guilty as charged. That is the process that will occur.
Ms. Frimpong, you look like you wanted to respond to that.
May I add something in? Actually, I believe that my colleague from OPD might actually be the best person to add on to this. But I do want to, make a statement, really want to clarify, right, that oftentimes what 287G does is it deprives a survivor's family from actually being able to seek and achieve justice. In a lot of cases, right, the people that 287G actually captures actually never make it through the criminal legal system where they go before a judge who says, yes, this person is guilty or not guilty. Rather, what happens is they are whisked over to ICE. They might be deported, they might come back, whatever it is, right? 287G does not give the criminal legal system a chance to actually function and hold offenders accountable. It deprives victims and their families from actually being able to go into court, tell their story, and have a judge make the determination. That is what we see in most of these cases, and I don't know whether Ms. Wolf would like to add on to that.
I think actually Ms. Shaw has the.
Yes, perhaps.
Ms. Shaw?
Thank you so much. And I want to thank the delegate for this really important question, because I think at the heart of this entire matter is how do we keep our community safe? And, hearing you talk about that young woman, it is completely heartbreaking what happened. So when I talk to law enforcement officers about what will help keep our community safe, one thing they've said to me is we need to keep our jails, we need to have control over our jails so that we are prioritizing the people who pose the greatest danger. That's not what the 287G program does, because being undocumented doesn't mean that you pose a greater danger than the person next to you. In fact, what we know about the dragnet approach to immigration enforcement taken by this administration is that they aren't prioritizing people based on the danger that they pose. In fact, only 3% of the cases of people who have been arrested in the last few months were of people who were convicted of a crime. What we also know is that overall, 287G doesn't drive down crime rates. There are studies that show this. One, the studies show that participation doesn't drive those crime rates down. It means that more people are brought in on misdemeanor charges. So you have more low-level arrest people who are in the jail, crowding the jail, taking up police resources. And we also know that non-citizens commit crimes at far lower rates. There are numerous studies showing that than citizens. I have kids, Delegate. I want safety for my family here in Maryland. I live here. But what I don't want is my local police prioritizing ICE's indiscriminate, reckless roundup of people over my own safety. And I want police resources spent on investigating serious crimes. And I want people in my community to feel like they can report when they see something and they believe that someone's in danger and not be afraid to do so. And unfortunately, 287G means that we are all less safe.
Thank you, Ms. Shaw. We'll move to Delegate Cardin.
Thank you, Mr. Chair. Thank you all very much for being here. Just, Ms. Shaw actually touched on it, but the young lady from the Public Defender's Office, you said in your original testimony, you were talking about the fact that I think it was like 1 out of 150 of the people detained had a criminal record or something to that effect. Can you just enlighten us as to whether, I mean, we're talking about whether this is making us safer or not and whether the police resources used adequately. I just was startled by that number, if you can maybe highlight it again.
So what I said was for every one person on whom there was a 287G detainer placed who had been convicted of a serious violent crime, there were 115, so 115, not 150, detainers placed on someone with no conviction at all. And another way to say that is that of the folks over a 7-year period, this is a sample size of over almost 800 people, 0.5% of them had a level 1 serious violent conviction. Almost 60% of them had no conviction at all. And 34% of them had just a level 3 least serious conviction. That category includes minor misdemeanors, minor traffic offenses.
Okay.
So the vast majority, 92%, had either no conviction or a level 3.
So this may be a little political right now, but when the vice president says we're only going after, I'm going to use his, violent criminals, that is not fair to say with this program. Is that correct?
Absolutely not.
Okay, I just want to make sure.
Thank you, Delegate Cardin. Delegate Valentine.
Thank you, Mr. Chair. And I do have a couple of questions. My first question would be for Amma. And this deals specifically with the victims and witnesses of crimes and some of the fears that you say are in those communities. You're familiar with the legislation that was passed just last year expanding those protections, correct? For the victims and witnesses of crimes that was expanded to protect them in those circumstances?
For, was it related to U visas?
Yes.
Is that correct?
Yes.
Yes, sir.
And the messaging, I'm sure your organization is putting out there so that that should not be a fear in those communities, correct?
As an attorney, I have a professional and ethical obligation to advise community members on all risks. And so when I engage with community members, I do also have to share the risks that exist when they're engaging with law enforcement that might be collaborating with ICE in an adverse manner to their interests.
But with ICE, I mean, the legislation was for law enforcement, so there would be no fear in that regard, correct?
Unfortunately, that is not correct.
That's not.
Right? And so despite the existence of legislation, if what people are witnessing is that law enforcement is acting contrary to their interests, of course they're still going to be afraid, regardless of what is written on paper.
And that leads into my second question. Some of the terminology you used in your testimony that I wrote down, died, tortured, captured, disappeared, pretty graphic terminology. I'm trying to get some of the information as to where, like, specific cases on this. Is that something you could provide this committee specifically as it pertains to 287G counties? Because those are specific instances that I would like to know about. If that's occurring in one of my counties, I represent 2 counties, I would like to know those cases of someone being tortured, captured, and disappeared. Do you have those available?
I have several stories and reports of community members who have indeed died, been captured, tortured, disappeared by the federal government. Whether or not those were specifically 287G related, I do not believe that I could provide the numbers. However, that is simplifying the issue, right? What is I see your...
Go ahead.
Sure. I mean, I think it's very important to understand the fact that our community members don't necessarily, may not necessarily understand the distinctions that exist between 287G versus non-287G. What they know is that law enforcement is collaborating with ICE. What they know is that people wearing uniforms perhaps might not be there to serve and protect them, but rather to detain and deport them. And so all that to say, yes, I can provide information. CASA runs a hotline through which individuals report immigration enforcement actions. And so we have plenty stories and reports that point to those facts.
I'm just trying to tie the specific 287G to reducing disappearing, torturing, and captures. I'm trying to correlate that. And I do have another question. And I'd also ask the panel, and this could be for anyone on the panel, I know we've talked about the field enforcement that is not taking place in Maryland, the jail component, and some of the other components. And I know we talk about, well, in the jail model, they're arrested. An individual is arrested. So at what point do you feel, anyone on the panel can answer this, would it be okay to cooperate? Is that post-conviction, an individual is convicted of a violent crime, and now would it be okay for a jurisdiction to contact and work with the federal government to satisfy that ICE detainer? At what point would it be okay for an agency or in a county to work with the federal government? Because we were tying in on arrested, not convicted. What about if it was convicted and the sentence is complete?
So I think it would be stepping outside my lane to draw the exact line for this committee. That obviously is what all of you in the General Assembly are here to do. But what I can say is the 287G agreements that are entered into by a county in Maryland, when it's a county jail that you're talking about, you are not ever going to be talking about the people who have been convicted of the most serious offenses. The homicides, the rapes, the offenses that horrify all of us get people sent to prison. And so those people are not walking out the doors of your local jail. The people who do walk out the doors of your local jail are people who are being released on bond because they have not yet had their day in court. They are being released after their case has been resolved without a conviction, so they've been found not guilty or the charge has been dismissed. They might have been convicted of a less serious offense that a judge did not deem worthy of a prison sentence. Perhaps it wasn't even ever subject to that much jail time. Maybe we're talking about disorderly conduct or, a driving offense. So those are the people that 287G targets. And so I don't think that there is anyone who's coming out of the local detention center. By and large, these are the least culpable people that get arrested. And so I understand there's another debate to be had about folks who have been duly convicted of a serious offense, but that's not who we're talking about here.
Last question, Mr. Chair.
I indicated that was the last question for this panel, but so I'm going to let that one go. And we've got two more panels. Delegate Aragon.
May I please step in, Delegate? Excuse me, Acting Chair. I lost my train of thought when I was responding to Delegate Valentine's question, and it just came back to me. And the point that I was trying to make about, the distinction about whether or not the statements I made were tied specifically to 287G, right, is the fact that it doesn't matter whether or not they're tied to 287G. Once they get into ICE custody, we know that these are the things that are happening to them, right? It does not matter whether it's a community arrest or a 287G transfer. We know that folks are being tortured. We know they're being murdered. We know that folks are being unlawfully removed from the United States. And oftentimes for us, it is actually impossible for us to follow up to find out exactly, was this a 287G arrest? Was it a community arrest? Why? Because ICE has unlawfully, expeditedly removed them already. So this is what we are seeing. And so it does make it really hard to even be able to get additional data to that point. But we do know that that is what is happening because we have the reports to show us. Thank you.
I want to thank this panel, and we will be bringing up the next panel. I'm not sure if all of these individuals who signed up to be in person are here, but I am going to read out the following names: Joanna Silver, Lorenzo Bellamy, Zainab Chaudhry, Angel Gonzalez, and I'll add Mary Fouché. Are they here or are they online? Mary Fouché is online, and who else?
Yes, I'm online.
Joanna Silver?
Yes,
Okay.
I'm here.
All right, very good. Then I will also then add is Taj Smith. Taj Smith, if you could come to the table. And Diana Bergman, if you could come to the table. We'll do those four, and then we'll move to the next set. Wait a minute. Let me see. Who else is here? Robert Van Rens. Christopher Kano. He's online? All right, bring him on as well. So we'll do 3 online and 2 at the table. We'll start with our 2 at the table, Ms. Bergman, and I just said it.
Taj.
Ms. Smith? Okay. And either one of you can start.
Okay. Good afternoon, Chair and members of the committee. My name is Taj Smith, and I'm president of the Washington County NAACP. I stand before you today in support of HB 444. 287G allows our county to detain someone based on a belief that a person is undocumented. This leads to racial profiling and policing. If I looked Irish, for example, I'm less likely to end up in a county detention center. Racial profiling is a direct violation of our Constitution. When we target people because they don't look like a citizen, we aren't enforcing the law, we are violating it. Washington County Sheriff entered into a 287G agreement without input from the community. We did not get to decide what we wanted. Instead of catching violent criminals, we are targeting people who look like immigrants. Data from our neighbor in Frederick County shows that the majority of these detained are held for minor traffic offenses and have no criminal convictions. This isn't public safety, it's a tactic designed to target Black and brown communities. We live in a rural county where racism is a daily reality. Because I'm Black, have an Arabic name, and may look Hispanic, I, like many others, are targets of these agreements. One of our county commissioners contributed to Project 2025, and it has now been confirmed that DHS has purchased a warehouse for ICE Detention Center in Hagerstown. Extremism holds positions of power in our county. Our county is in danger of becoming Minnesota. Our communities are living in fear. You were elected to protect everyone who lives and works in your districts, and HB 444 is your opportunity and duty to uphold human rights in our immigrant neighbors and our constitutional rights of us all. We urge you to have a favorable report for this bill. Thank you.
Thank you, Ms. Bergman.
Greetings. I'm Diana Bergman, a Carroll County resident y soy orgullosa de ser cubana, madre de tres, and a spouse of a veteran retiree. I live in Carroll County, where one sheriff, one individual made the decision to sign on to 287G agreement without public input or fully understanding the unintended consequences of harming our community throughout Carroll County. I'm here today to share what I've been seeing in Maryland. I feel like I see ICE everywhere, and I'm not talking about the ICE from the recent storm. As I drove down 695 today before getting into 97, I looked over to my right and I witnessed a Homeland Security federal vehicle heading towards off-ramp of Arbutus in Baltimore County. My heart sank because I know that's the same exit where many Latinos reside in Baltimore County. I worked for Baltimore County Public Schools as a Spanish interpreter to give families language access. And I know a lot of families are scared. I've been seeing things just by speaking up because I believe that children should not fear going to school and it should be safe. In my county, guess what? They acted policy to allow ICE to come into the lobbies of schoolhouses, okay? It is very difficult when you're trying to explain families that are coming here for a better life to get an education for their kids. That education is something rooted in our public education system. And they're not coming forward. I see our school enrollment numbers like declining because they're scared. I'm a US citizen. I became a US citizen in 2008, and I am scared. I am scared because of the things I've seen. I participated publicly when our delegates had their pre-session hearing, and I had a community member loud shout at me because she didn't like what I had to say. You know what? It is not okay what we're seeing on TV at the national level. It could very well happen here. Thank you for your time.
Thank you, Ms. Bergman. We'll go to Ms. Silver.
Thank you. My name is Joanna Silver. I'm testifying in my personal capacity, but I've worked for over 20 years as a federal public defender here in the District of Maryland, representing people involved in both the criminal and immigration legal systems. Through my work in the past year, I have witnessed ICE prioritize deportation over everything else, acting with a complete disregard for due process and undermining rather than enhancing public safety. For example, a couple of years ago, under the last administration, I represented an individual charged with illegal reentry. While that case was pending, an immigration judge granted him protection from future deportation to his home country under the Convention Against Torture. This gentleman served his criminal sentence and was doing well here in the community. After Trump took office, however, ICE arrested him again and deported him to a third country. Within weeks, that country sent him back to his home country, the very country an immigration judge had said he was not allowed to be deported to. Now, while we expected a sharp increase in illegal reentry prosecutions under Trump in the name of public safety, particularly for people with serious criminal histories, that increase never came. In fact, we saw illegal reentry prosecutions drop last summer when ICE was sending all of its officers in the region to occupy DC. ICE is so focused on deportation over public safety that for the first time ever, we are seeing them deport people who are released pre-trial by the judge in their federal criminal case, preventing their prosecution from moving forward. To be clear, one federal agency, the Department of Homeland Security, is undermining another, the Department of Justice, with deportation prioritized over accountability for alleged criminal conduct. These practices do not make our communities safer because that is not ICE's goal. This state cannot allow our local governments to work on behalf of this rogue organization. I urge you to issue a favorable report on HB 444. Thank you.
Thank you, Ms. Silver. Ms. Fouché.
Hello, can you hear me?
We can. We don't see you just yet.
I think the host has disabled my video, my camera.
Give us a moment so we can try to figure out the technology.
Thank you.
It's not disabled. Your video is not disabled.
I try opening it, it's telling me the same thing. You cannot start your video because the host has disabled it.
All right. Well, what we will do is we will allow you to testify even though we cannot see you.
Okay. What about now?
Here we go. We have you now.
Okay. Thank you. Good afternoon, Chair and committee members. My name is Mary Fouché. I'm a public health physician and resident of the Eastern Shore. I support HB 440 because 444 because 287G does not make communities safer. It makes them silent, and silence kills. By supporting HB 444, let's be clear. We are not protecting criminals. We are for due process, not personal vendettas. And any immigrant accused of anything, and if it is worth arresting, could be deported. Innocent until proven guilty does not prevail for immigrants. This administration is manufacturing illegality by ending legal programs. And you heard over and over all the testimonies about TPS and DACA. So this administration is manufacturing illegality. Fear and terror. This is what agreements like 287G implement in communities. And you can ask Kevin Martinez family about fear and terror. Maryland should not be in the fear and deportation business. We need to improve immigration laws. We need to improve foreign policies to ensure the stability and the economic growth of the America. The same way that the United States with Europe after World War II, they need to pay the same attention to the countries in the Americas and fix immigration issues and human rights violations once for all. Let's treat immigrant community members as human beings. Thank you.
Thank you, Ms. Fouché. Mr. Kano.
I am here. It is giving me the same message that my video is disabled by host, so if staff could fix that. Awesome. Thank you.
Yep.
Got it.
You're coming on now. Thank you.
Right.
And I misspoke. In order to testify, we must see your video. So, but thank you, Mr. Kano.
All right. So SCLU Local 500, which I represent, has over 20,000 public sector and nonprofit workers across Maryland that include educators, public employees, and frontline workers who serve diverse communities each and every day. And many of our members derive from or live and work alongside immigrant families. They understand firsthand that community safety depends on trust, not fear. So let's be clear about what 287G really is. It is not about public safety. It is about turning local law enforcement into an extension of a federal deportation machine that is engaged in a racist, state-sanctioned human trafficking campaign that is corrosive to our Constitution. ICE and CPB have built enforcement regimes that rely on racial profiling, suspicion without evidence, and fear without accountability. Black and immigrant communities are targeted, families are torn apart, and due process is treated as an inconvenience rather than a right. That is not law enforcement. That is state-sanctioned discrimination. 287G agreements drag Maryland counties into this mess. They blur the line between local policing and federal immigration enforcement, undermine the Fourth Amendment, and destroy trust between communities and the very institutions meant to protect them. When people are afraid to call 911, everyone is less safe. When union members are gunned down in the streets as legal observers, everyone is less safe. Maryland should not be complicit. Our values demand better. Ending 287G is about defending civil rights, upholding the Constitution, and saying clearly that racism and fear have no place in our public policy. And the fact that anyone in this General Assembly will continue to support the erosion of our Constitution is a dereliction of duty and oath of your office. Now, this bill reinforces clear and appropriate division responsibly. Civil immigration enforcement is a federal function, not a local or state one. Drawing this line, this bill protects civil liberties, promotes effective policing, and ensures that all Maryland residents, regardless of immigration status, can access public services without fear. Marylanders deserve smart public policies that value fairness, inclusion, and strengthen communities, support workers, and make it clear that cooperation with law enforcement should never come at the cost of basic human dignity. Therefore, we respectfully urge a favorable report on this. Thank you for your time.
Thank you, Mr. Kano. I see we have Ms. Monica Brooks, and before you begin, is Ms. Ramirez, Lillian Ramirez here. Tatiana Santos. She's online. Okay, all right, then I'll come back. All right, let's go with Ms. Brooks.
Okay. Sorry about that. Good afternoon. My name is Monica Brooks, and I'm testifying on behalf of Wacomico County and AACP in strong support of House Bill 444. Over the past year, our communities have organized countless protests, meetings, and town halls calling for an end to 287G. Hundreds of people have spoken out at our public forums and county council meetings, and at all of those times, we've only had one person speak in support of not banning 287G. So our message is clear. We don't want it. Marylanders don't want it. The Eastern Shore does not want it. Only certain elected officials want it. That's why it was deeply disappointing for our sheriff and county executive to just this week, in an act of defiance, to enter us into a 287G agreement. They're saying it's public safety, but we reject that. Public safety cannot exist where fear is being institutionalized. And 287G is being prioritized over actual public safety. On the Eastern Shore, we're already at a deficit. We don't even have enough law enforcement just to do the day-to-day things that we currently need. So instead of recruiting and training and retaining officers to address real crime and community needs, time and resources are being diverted. Wacomico County knows firsthand the human cost of aggressive immigration enforcement. Our community experienced the trauma of a mother being taken into detention while her teenage son was battling cancer. And the stress of his detention, his mother's detention, led to him passing away. She did not get to see him before he died. Guilty criminals should be held accountable whether they're citizens or not, but when undocumented people are denied due process, it opens the door for anyone and everyone to be denied due process, which is what we're seeing. And across this country, aggressive immigration enforcement has resulted in American citizens, legal residents, and children being wrongfully detained and harmed. But more importantly, these systems overwhelmingly target Black, Brown, and Indigenous people. I'll go to my last line. House Bill 444 is about restoring dignity, accountability, and real public safety, and it reflects the will of the people and the values of Maryland that we claim that we stand for. The NAACP Wacomico County urges a favorable report on House Bill 444. Thank you.
Thank you, Ms. Brooks. Do we have questions for this panel? All right, not seeing any, I think, well, Delegate Moreno.
I have one for the union, SEIU. Is he still on? I'll go ahead and ask it. I think it'll appear once he speaks. Can you elaborate on any of your union brothers and sisters that may be immigrants and talk about their character?
He's already dropped off.
He already dropped. All right, then never mind. I retract my my time.
All right. Thank you very much. And we just have a couple of more on the favorable panel, so I'll thank you, Ms. Bergman, and yeah, thank you very much. All right. Is Ms. Tatiana Santos online, Ms. Viviana Westbrook, and Mr. Matan Zimmer?
I'm here. Tatiana's here, and I'm also having problems with starting the video. So.
All right, we'll get you started in just a second.
Thank you.
And who do we have? I want to make sure I'm clear on who's sitting in front of me.
Liliana Ramirez. Liliana Ramirez.
Okay.
Matan Zimmer.
Okay.
Viviana Westbrook.
Very good. And Tatiana Santos is online. Okay. Very good. All right. We'll start here to my left, to your right.
Thank you so much. My name is Viviana Westbrook. I am the state and local advocacy at Catholic Legal Immigration Network, otherwise known as Clinic, and I'm here today to testify in support of HB 444. Previously, I worked for many years with immigrant survivors of gender-based violence, which I still do today on a pro bono basis. I have seen the negative impacts of these agreements when immigrants see 287G agencies and as an extension of ICE. 287G destroys community trust. This is a public safety issue. We see the chilling effect among immigrants and refugees who become victims of crime but are too afraid to report it. Ensuring that everyone in our community feels safe to report crime to our local law enforcement makes us all safe. 287G agreements lead to local residents losing trust in the very law enforcement agencies that are responsible for maintaining public safety. Abusers will make accusations against survivors. In 287G jurisdictions, this means ICE is alerted to the arrest. Once a survivor is in jail and 287G activates, ICE will learn of the survivor's immigration status. This can result in the immigrant survivor being detained, having to fight their case in immigration court, or in some cases, may even be summarily deported. Over the summer, I observed a packed room for a 287G meeting with the Frederick County Sheriff and his office, where every last community member in attendance spoke out against 287G. In this meeting, the sheriff refused to say he would not enter into a task force model of 287G. That's the one where you would be policing in the community. Even though, right now by law, it's not allowed, but the fact that he wouldn't even say that is telling. So, we have seen how the violence that is currently being perpetuated is complicit. 287G is complicit in this violence. And so I ask for a favorable report on HB 444. Thank you.
Thank you.
Good afternoon. My name is Matan Zimmer. I'm the Maryland Policy Director at Jews United for Justice. But today I have the great honor of testifying on behalf of the Maryland Immigrant Justice Table, dozens of whom are tuned in online right now and watching. For more than a decade, CASA has led the Immigrant Justice Table, which started as a group of 9 or 10 individuals, has grown into an extraordinary group representing nearly 100 organizations and communities, representing thousands of Marylanders, which meet each week to discuss how we're going to protect immigrants in our state and resist the racist and xenophobic attacks by the federal government. This includes advocacy groups, business groups, service providers, unions, teachers, principals, faith leaders, students, nurses, doctors, and many others from Mountain, Maryland to the Eastern Shore, including Frederick, Washington, Wacomico, Cecil, Hartford, Montgomery, Prince George's, Baltimore, and many other counties. As you'll see, There are more than 200 members of the Immigrant Justice Table who have submitted written testimony in favor of HB 444. While you're not hearing from them verbally today at this hearing, please know that their voices are very loud and very present in this space. Each day we see how federal agents are given free rein to carry out state violence against residents with no accountability. We see neighbors, friends, colleagues, and family members terrorized, kidnapped, and by mass federal agents, and we witnessed a devastating impact on their loved ones. We are outraged, we are heartbroken, and we are determined. The thousands of Marylanders represented by our organizations have a clear demand for the General Assembly. Uphold Maryland's values of fairness, dignity, and justice for all by finally banning 287G agreements in Maryland. This is an incredibly important step that this legislature must take and is part of a package of bills that must pass this year, including legislation to further protect Marylanders' data, building on previous success, and putting an end to any local law enforcement collaboration with ICE. Our state should not be in the business of tearing families apart, terrorizing communities, and eroding public trust. Instead, Maryland should remain focused on the well-being of all residents regardless of immigration status, community safety, due process, and equal treatment under the law. So for all of those reasons, on behalf of the Immigrant Justice Table, I respectfully urge this committee to issue a favorable report. Thank you.
Thank you, Mr. Zimmer.
Hi, everyone. My name is...
Our youngest witness of the day.
Hi, everyone. My name is Liliana. I'm 10 years old, and I am in the 4th grade. I am a member of CASA. I was born right here in Maryland, and my family is from El Salvador. Today is the first time I'm ever testifying on a bill. I am here today because even though I'm 10 years old, only 10 years old, I know my voice matters, and I know my voice can make differences. I have 4 brothers and a sister. My little brother is just a baby. He is only 1 year old. On December 30th, my life changed. My dad was taken away by immigration. My dad was a good dad. He worked hard every day to take care of us. He does go to church with us. He helps people, and when he comes home from work, he always makes time to play with my siblings and me. Soccer is my favorite game to play with my dad and my siblings. That day, my dad went to his construction job in Frederick, like he always does. Always did. But my dad never came home. ICE was waiting for him in the park, waiting for him and the other workers in the parking lot. They were taken because they speak Spanish and because they were immigrants. Since my dad was taken away, our home felt empty. My mom cried a lot. She is getting sick of the stress and don't know how to take care of everything by herself. My older brother can't focus in school anymore. It is hard to worry about grades when you are scared to be taken too. My baby brother cries all the time. All the time. My dad used to play with him until he falls asleep. He's just a baby, and he doesn't understand why his dad is gone. I'm scared too. I miss him. I miss my dad every day. I worry about my family, and I'm testifying here today because I love my dad and I love my family. I love my community. Please stop letting Maryland be a place that helps ICE hurt families. I know this bill will help this. I support this bill, and I ask all leaders in Maryland to support it too. And to support family like mine. Thank you.
Thank you so much for being here. That was wonderful. Really brave. Thank you.
Thank you.
Would you like to go next? Would you also like to talk? Oh, sorry. Okay. Thank you. Ms. Sanchez?
Thank you. Thank you.
Hi, am I on video?
You are. We can see
Okay,
you.
great.
Thank you.
I couldn't figure out how to disable it, so I just wanted to make sure it was coming through clear. Thank you. Good afternoon. My name is Tatiana Santos, and I'm a resident of Frederick, Maryland, where we have one of the longest standing 287G agreements in the country. I'm speaking today in support of HB 444. 2 months ago, I was stopped by local police for what the officer told me was expired tags. My tags had just been renewed and the sticker on my license plate read 2029. So the fact that they were expired was disputable. After 15 minutes of exchange where the officer asked me for my license, my registration, and ultimately my insurance card, it was determined that there must have been a glitch in the MVA system. I was given a warning. When I got home and read my warning document, I noticed under the race section, it listed Hispanic in bold letters. At that moment, it became clear that I wasn't stopped for expired tags, but rather for driving while Hispanic. That experience left me wondering what would have happened if I had an accent or didn't have the right documents on me. And can I even trust police in future interactions with them? My situation isn't unique. In my community advocacy work, I recently interviewed a family whose loved one was stopped by the police for having an expired license. Uriel was taken into custody for driving with an expired license and deported. People shouldn't go to jail for expired licenses. His family, which includes a 6-month-old baby, is now falling on hard times. They have a fear of leaving their home and of having any type of interaction with local police officers. I support HB 444 because immigration enforcement agreements like 287G create fear in immigrant communities and undermine public safety for everyone. When people fear contact with law enforcement, they are less likely to report crimes, seek help, or cooperate as witnesses. For these reasons, I respectfully urge the committee to issue a favorable report on HB 444. Thank you.
Thank you, and thank all of you for your testimony. Are there any questions of this panel? All right, seeing none, I think that concludes the favorable witnesses for HB 444. Thank you all very much. We're now going to move, I guess we're going to do, in the interest of time, we will do favorable with amendments and we will begin the unfavorable panel. Mr. Zach Moreland, Mr. Eric Roby, Michael Cronis, Sheriff Charles Jenkins. Mr. Moreland is not here. Okay. Then we will add to that panel. We've got 4 seats up there. A.K. Kinney. A.K. Kinney.
She's actually county executive. She's my secretary.
Okay.
75, she doesn't care.
Okay. County, and I'm sorry, County Executive, you are?
Yeah, it's Julie Giordano.
It's Giordano. We're going to, I think normally we wouldn't do this, but you are the County Executive. We're going to give you some grace.
Thank you.
All right.
I'll let my secretary know.
Yep.
Thank you.
And you know what? We're going to bring another seat up. Mike Lewis. Very good. All right. And since you were the last one to join the panel, but you're furthest to the left, we'll start with Mike Lewis.
If we could, sir, I'd like to follow my county executive.
Okay. That's fair.
And I would like to defer to her first.
You know, I'm new at this, and you're a smart man. Madam County Executive Giordano.
Yeah, all right. Yes, good afternoon. I just wanted to do a couple points of clarification before getting into this.
287G is no additional cost to our counties, so I just wanted to put that on the record. The second thing is that 287G under the contract itself actually protects counties from liability. And actually no one, and I know these gentlemen will reiterate this, no one in law enforcement is involved. So I just wanted to put those things on the record. Public safety is not a partisan issue. It's not a campaign slogan, and it's not an abstract talking point debated in distant political circles. Public safety is the foundation upon which freedom, opportunity, and prosperity are built. Without it, nothing else matters. And that is why I strongly and unequivocally oppose House Bill 444. This legislation, which prohibits the state of Maryland and local governments from entering into immigration enforcement agreements with the federal authorities, creates a dangerous outcome. It means individuals who are arrested and already in our jails could be released back into our neighborhoods instead of being safely transferred into federal custody. It means violent offenders and repeat criminals could be returned to our streets. This bill does not make Maryland safer. This bill does not make Wacomico County safer. It makes our citizens and communities more vulnerable. Programs like 287G are not about politics. They are guardrails. They are the only meaningful tools that we as elected officials have to ensure that ICE operations occur within the walls of our jails, where dangerous offenders can be handled safely and securely without putting the public at risk, rather than being forced into our neighborhoods, workplaces, and schools. In recent remarks during a National Desk Live interview, Border Czar Tom Homan explained that if they let us in the jail, we could arrest the bad guy in the safety and security of the jail. So if they don't let us in the jail, we're going into the community. While I disagree with the legislation, I do respect differing viewpoints. However, it is critical that this committee and the public understand the real-world consequences of what is being proposed. I just want to say this last thing. This legislation does not stop ICE. Every person that I've heard that is for this bill thinks that you are going to legislate ICE out of Maryland. That is not happening. And I think that you need to be honest. ICE is here, and ICE is going to be ramped up. Please do not take 287G away, the only guardrail I have to protect the citizens of my county. You're going to take it away, and ICE will be in our communities tomorrow.
Thank you.
Thank you.
County Executive. Ready.
Thank you, Mr. Acting Chair. You look good behind that chairmanship there with your gavel. Eric Roby, Director of Legislative and Community Affairs for the Harford County Sheriff's Office. I just want to start out by saying we've had this program in Harford County for the last 8 years, and I feel like I know this. I don't know this program as well as Sheriff Chuck Jenkins does because he's the longest in the country, but I feel like I know this program pretty well. And I heard a lot of stories from the proponents that came up here to speak, and none of them, to me, from what I've seen in our community, applies to what our 287G program does. I'm proud in Harford County that we have had multiple steering committee meetings, and less than a handful of residents have come to oppose our program. They support our program. We worked hand in hand with LASOS, which is our immigrant organization in Harford County, when we first entered into this agreement. And by the way, we entered into this agreement under President Barack Obama's administration. The program was created by President Bill Clinton, a Democrat. So this program has stood the test of time for multiple administrations. We worked with our stakeholders. We put together a plan. We told our community exactly what this program is and what it isn't. What it isn't is a law enforcement program. What it is an individual that gets arrested, brought in, and booked into our detention center, that then they are screened to determine whether they are in this country illegally. And while I know there's a lot of tension throughout the country right now, there's a lot of stories about everything that's happening out in Minneapolis, the stories that you heard here today, folks, are not the 287G program. Nobody gets booked in our detention center for having a minor traffic violation. It doesn't happen. It doesn't happen. So with that, on behalf of the Maryland Sheriff's Association, on behalf of the Sheriff of Harford County, I'm asking this committee for an unfavorable report on the bill. Thank you.
Go right ahead, sir.
Good afternoon, Mr. Chairman, committee members. I'm Sheriff Chuck Jenkins, Frederick County. We are the longest standing 287G program of any sheriff's office in the country. I'm not going to be redundant, but I will tell you, how can you vote with a clear conscience to end a program statewide that will potentially bring harm to the communities you want to protect? It doesn't make sense to me. Every program in the state of Maryland is a jail model program. There are no task force model programs. I'm afraid of if this bill passes, I fear what you're going to see in this state. I know what's coming. This is going to boomerang. You are going to see ICE making street apprehensions all over the place, everywhere. That's not what we want to see. None of us want to see that. I'll bring up an analogy. So about 6 weeks into this administration, I got a call from the state director of removal operations with ICE. He said, Sheriff, he said, we've established our first list of 65 priority criminal targets in the Western Maryland region. Western Maryland is Frederick and Points West, Frederick, Washington, Allegheny, Garrett. We are by far the most populous. He said, because of what you've been doing in Frederick County for 18 years, long before Trump, like I said, I got in it under President George Bush. He said, because of what you've been doing in your county, we don't need to be there. You're removing the criminals. So that's an example of what you may well see if you kill this program. And again, I promise it's going to boomerang. I'll just bring up one other point. So I met with 2 employers this weekend, had conversations. One was a major trucking excavating company. The other was a major contractor who deals in all the trades. He said, Sheriff, if they pass this bill, he said, what you're doing, they both said, what you're doing in Frederick County works. If they kill the program and ICE comes, the workforce will disappear. You'll never find them. You'll never see them. So keep that in mind as you vote today. So I would ask for an unfavorable ruling.
Thank you, Chief.
Good evening. I'm Lieutenant Colonel Michael Cronice. I'm the Corrections Bureau Chief for the Frederick County Sheriff's Office. Currently, the 287G program in Frederick County is only conducted in the detention center by correctional officers. There are no police on the streets, in the schools, or in the hospitals, or anywhere in Frederick County that are part of the 287G program. Only people that have been arrested and charged with a jailable offense are transported to the detention center. No one is brought into the detention center for a non-jailable offense, such as speeding or a headlight being out. This doesn't happen. The booking system at the detention center will not allow someone to be entered into the system for a non-jailable offense. Everyone that is brought into the detention center is asked the same series of questions. This practice maintains consistency and eliminates profiling. Frederick County's 287G program officially started April 11, 2008. During that time, the program has screened 6,450 arrestees that claim to be foreign-born and/or not U.S. citizens. Out of the 6,450 arrestees screened, only 2,153 detainers were lodged. That's 1/3. The remaining 2/3 had no action taken. Out of the 6,450 arrestee screens, there were 443 prosecutorial releases. These releases were on arrestees who were vetted and determined to be in the country illegally. However, no action was taken and no detainer was lodged. Prosecutorial releases can be for humanitarian reasons, medical reasons, child custody issues, or minor charges. In my opinion, the removal of the 287G program from the detention center would result in immigration enforcement being conducted in everyone's communities instead of in the jails. The Frederick County Sheriff's Office is opposed to House Bill 444. And if I could make one more comment, there was a statement made that there's no consideration for charges being dropped. About 6 weeks ago, we had an individual that was brought into our central booking unit. He was screened. It was determined he was in the country illegally. When he went to see the commissioner, the warrant had been recalled. We took no action, no detainer was lodged because it was determined that the warrant was recalled. Over at least 2 separate times, I've personally encountered people who claim to be citizens of, one was Peru and one was El Salvador. After we vetted them, we were able to determine that they were U.S. citizens.
Thank you, sir.
We do a comprehensive, thorough vetting before we lodge a detainer on anyone.
Thank you.
Thank you.
Mr. Chair, distinguished members of this committee, Sheriff Mike Lewis, Wycomico County, Maryland. I just want to state, and I don't have any particular notes, that please don't let our emotions cloud our judgment. ICE is here to stay, at least for the next 3 years. ICE is going nowhere. And as Madam County Executive said, there are so many people who believe that legislation here in Annapolis will ban ICE from ICE activities in the state of Maryland. It will do nothing but ramp up those activities. I've had personal conversations with ICE members because of some things that have occurred in my county, some things that need to be addressed. housekeeping chores, just the way they were conducting business. Nothing egregious, but I was very concerned about a couple of things that were taking place. I requested a meeting, and I met with them. And they made it very clear to me that temporary protected status for other individuals in our community was about to expire, and additional ICE members will be coming into Wycomico County. I met with my county executive, and we wanted to explore our options for this 287G program. And we agreed we have to do it. There's nothing I want any more than to be able to safely transfer someone who's in our custody already on local charges and transferring them into the custody of ICE in a very secure environment. If we don't do that, ICE will go to their homes, and they do have the lawful and legal authority in given situations to kick the doors in. And I couldn't help but think about the testimony of this beautiful 9-year-old sitting behind me a while ago, how traumatized she would be if ICE kicked in her door to get her father or another loved one. And when they do come into their homes, they will secure everyone on the floor. They will get IDs from everybody in the house. And those hardworking, otherwise hardworking immigrants, regardless on whether they had warrants from or not, if they're in this country legally, they're all going. And we have an opportunity here today to control that. I hope we all issue an unfavorable ruling for HB 444. Thank you very much, Mr. Chair and distinguished members of the committee.
Thank you, Sheriff. Are there questions for this panel? Yes, Delegate Erica.
Thank you, Mr. Chair. Thank you all for being here today and coming through the ice and snow to get here. We heard a lot of hyperbole in the previous panels. Also, we heard that there was people being disappeared, killed, this sort of extrajudicial language. Are any of you aware of any cases like that where people are just vanished?
I am not in Frederick County.
No in Frederick? No in Hartford? No? Okay.
Absolutely not.
All right, well, that's good to know. Also, if you guys could just go down the line, we heard that these are low-level people, broken taillights. As Mr. Roby said, that's not how you get booked in Hartford County. I'm sure that's not how you get booked in any county. But can you tell us in your counties what some examples are of some folks that were caught, the crimes they actually did commit against our citizens? Just go down the line with each county and let us know some of the actual people we've arrested and the crimes they've committed.
Murder and attempted murder, 34 individuals. Domestic violence, 173.
173.
Aggravated assault.
173 for domestic violence?
Yes, ma'am. Yes.
Wow.
Armed robbery, sex offense against a minor, 66. Sex offenses otherwise, 52. Possession with intent to distribute, 30. 131 transnational criminal gang members, to include MS-13, Sinaloa cartel, and 18th Street. A number of them with specialized military and guerrilla training. And I got to tell you, the list goes on. And any crime, any arrestable crime you can think of, have been brought into our detention center, processed, and held under this program.
Excellent.
So I
Do
won't
you have
argue
lists
with
you want to
anybody,
share?
this makes a safer community.
The list goes on, and I've got nearly 200 on my list. The ones I've highlighted, I want you to look at all the yellow highlighting on my piece of paper, on these papers.
Yeah.
All those are highlighted. First-degree murder, first-degree murder, attempted first-degree murder, second-degree murder, assault in the first degree, assault in the first degree, assault in the second degree, multiple rape, child molestation charges, child abuse cases. The list goes on and on from Wycomico County.
Okay.
And when I met with my county executive, I said, we have got to move forward. We can't wait, because we're doing a huge disservice, not only to our U.S. citizens, but to our immigrant community, because we have to intervene. If we're allowed to work with ICE, as the county executive said, we are the guardrails that can control what happens. If we're prohibited by law, it's carte blanche in my county, and I don't want that.
No, none of us want that. I'm just looking to the audience to make sure the folks that testified earlier, hi, I see you. Did you hear that? You all said that they were, getting taillights broken and arrested. They're rapists, murderers.
Let's direct the question.
Delegate,
I just want to
thank
make
you.
sure everyone's awake and listening to what's actually happening.
No, and I appreciate you saying that. I do want to say that on that list that the sheriff holds in his hand, there's not one with a broken taillight. There's not one DUI. There's not one, lower level crime, so to speak. I mean, we are talking about dangerous people that I just, as the county executive, cannot have back out on our streets.
Absolutely.
I cannot.
Madam County Executive, and to
Ma'am,
the
you
panel.
can't- you cannot
Hold it,
book
stop.
someone-
Wait 1 second. I got a question
Yes,
that I
sir.
want to be clear on. For those individuals that you've just listed, they all, in essence, committed some type of jailable offense, truly a jail, and your prosecutors would then prosecute them, correct? I'm trying to understand what the equating this idea that you've got to go 287G when they've now committed a crime that they could be jailed and prosecuted for and not released. Is that correct?
Sure. So in answer to that, so we've just signed on to this. So ours is a little bit different. So some of the jail enforcement models, so we have the warrant service officer model is the one that we're going for. I will tell you on this list, it actually lists whether they're in custody or not. And I will tell you first-degree murder in custody. Attempted first-degree murder in custody, sex abuse of a minor, not in custody. So I will tell you, if you go down that list, there have been several that have been released back into our community. What the 287G allows us to do is only gives us an additional 48 hours to have ICE vet the people before they're put back out on the streets, whether it's on their own recognizance or they've made bond. So, it's working with them, in another, in an additional way, I guess is the best way to put it. Sorry, go ahead.
You're absolutely right. And if they get released back into the community, and there are many times they make bond and they're released back into the community, obviously they're a flight risk, but they also are committing more crimes. I too have followed Dakar Thompson's case in Prince George's County. That precious young girl was kidnapped and brutally murdered, and 9 days later in August, her badly decomposed body, was discovered along US Route 50 in Prince George's County. But the individual who killed her was out on bond on a DWI charge. He should have been held. And had that been an ICE or 287G county where we have been working collaboratively with ICE, he would have been held on that DWI charge. Instead, he was released. And he was able to commit a heinous murder in Prince George's County of a precious 19-year-old girl right after her graduation from high school.
Thank you, Sheriff. I'm going to move to Delegate Mangione.
Thank you, Mr. Chairman, and thank you all for being here today. So just a couple of questions. The good delegate from Harford County asked, and you answered about some of the very, savage individuals that have been held in your detention with help and assistance from this program. But I, again, want to just kind of set the record straight on a number of questions here that we heard earlier from testimony that basically I think really, I would just say, in my opinion, is lies that are being told. So I want to ask you, and I will just, you, Sheriff Jenkins, if you can please have a number of questions here. So just yes or no, just to keep it short, because we've been here a while. But you're saying you're not detaining people or putting them in jail simply because they're black or brown?
No, not at all. Never. No. You can't. No, but never.
Are you arresting American citizens, torturing, capturing, and disappearing them?
No.
Do you, based on your decades of experience, think that 287G makes Maryland more safe?
I truly do. I know it's proven to be in Frederick County, and I believe it will do so across the entire state if you allow counties that want to participate to participate.
And with all due respect to the comptrollers here, and since I did ask her a question, I'm not trying to just say something now she's not here, like I'm doing it behind her back. Do you think removing some of those individuals that you all discussed has a negative impact on the Maryland economy?
No, not at all. I really don't believe it does, no.
And I'll ask one more question because Dakar Thompson's name came up, and you could say Kayla Hamilton from Harford County or Rachel Morin from Harford County. There are many others. Does cooperating with ICE and having 287G and using these federal resources potentially prevent another situation, or at least potentially help to prevent? Not saying it's a guarantee.
Absolutely, especially in the realm of child sexual abuse.
Thank you for setting the record straight.
Could I add one thing to that? I just want to say this. Knowing 287G, I've done a lot of research on this, and I will tell you, it honestly shocks me because I would assume every legislator should be voting to mandate 287G agreements because they keep enforcement where it belongs. We all are saying the same thing. It doesn't matter if you're Democrat, Republican, conservative, liberal, we're saying the same thing. We don't want ICE on our streets. That's what we're saying. We don't want them in the community. And if you vote for this bill, if you put this bill forward, you're voting for more home arrests, more work raids, more neighborhood enforcement action. That's what you're voting for. And so I just implore you, I mean, we all should be doing 287G because again, it's keeping that enforcement inside the jail and not on the streets of Maryland. You are inviting Minneapolis to Maryland.
Thank you, Madam County Exec. We're going to go to Delegate Moon.
I was going to ask one question, but let me start with just asking a question about that last statement first. Thank you, Mr.
Sure.
Chair. Is the suggestion that ICE is so out of control and violent that we better cave to some of their policy demands lest they run rampant on the streets of Maryland?
No, and thank you for that. No, that's not what we're saying. What we're saying is that when you take 287G away, if ICE, I'm just going to use a person's name, if ICE is after John, they're coming to get John. Let me give them John in my jail rather than in John's house and then taking all of John's family. That's what I'm asking of you today.
Because that's what they do.
That's what they're going to do. Absolutely. So my point is that is it better to work with the agency? All the other three-letter agencies we work with, the CIA, the FBI, the DEA. But for some reason, we're just saying, no, we're not going to work with a group of individuals.
The one agency. Well, I was going to ask you
Right.
about all of you about that, because
Sure.
that's sort of the heart of the matter. When we had this bill last year, we had a very different conversation about it. And I think you're acknowledging that the situation on the ground is different this year. And so I guess you're right. The one agency is the source of my question. So as regards the jail enforcement models and 287G in the Maryland counties, I guess I do have a question now that would be different than last year. If someone's processed through your county's program, do you have any say over where they're transferred to after they leave your hands?
No, sir, we do not. Totally out of our hands.
Is it possible then that our counties become the gateway to CCOT in El Salvador or Alligator Alcatraz or Guantanamo, the three different staging grounds that ICE has been very big on pumping?
We have no way of knowing where they go.
But they could go there.
Potentially.
Is a conviction required for someone to get processed through your county?
Pardon me?
Is a conviction required before someone is processed through your
The
county?
case has to be adjudicated. Now, sometimes, and I think I'll take a step
Is a
back.
conviction, it's a simple question, is a conviction required before someone is processed for
Each
deportation?
case has to be adjudicated.
60% of our inmate population is not convicted. They're awaiting trial.
60%, okay.
Correct.
So they could go to CCOT, they don't need a conviction.
I'm talking about
And-
all the county,
I
all
understand.
the inmates within the facility.
Now I want to get to the offenses, and I don't know what's going on here. I'm not really that tech savvy. I haven't learned ChatGPT and all this stuff yet. But when I ask AI the questions to just fact check, I'm literally asking it things like, do 287G jail enforcement models in Maryland lead to people being deported for nonviolent offenses or frivolous offenses? And every time the answers are saying yes on all of my AI prompts. So audience and the public, you can follow along with me and try these searches yourself and see what links they lead to. Why do they say that? And they list specific counties, including specifically saying that Frederick County has some, for years, dating back to 2008 to 2012, has traffic offenses being a majority of the 287 detainers.
I just want to comment really quick on the ChatGPT. So I was a teacher for 17 and a half years before I was sworn in. One of the first things we teach our students is that don't trust everything you read on the
I get it.
internet.
I'm asking you to respond to
Yes.
why there are results telling me that multiple Maryland counties do in fact have people being processed for deportation, and you're telling me potentially to El Salvador and CCOT. Why is this information out there?
It could also be that it doesn't account for prior convictions. We had an individual that was brought in for, I believe, DWI.
In other words, they did their
Had a-
time.
Well,
They get picked up for something else, maybe a minor offense.
The person had a prior conviction in another state.
How old does it have to be?
It's a case-by-case basis. Decisions are made case by case.
Who's making that decision?
ICE makes that decision.
ICE makes that decision.
Absolutely, yes. Correct.
So again, we are the gateway for ICE's discretion on this. We've acknowledged that they're dangerous on the streets of Maryland. We've all agreed to that, right? And we've agreed that they could be sent to CCOT. So we do,
So
have I said
Delegate Moon,
anything wrong?
I'll give you a perfect.
Have I said anything incorrect?
I'll give you a perfect example. It's ICE that sets the priorities. They're the ones that makes the determination.
So
That
you've
individual
delegated
would
that
go
to them. We're doing their job for them,
That
right?
individual would go through a due process. They would go through an immigration hearing before they were, if they
Is
were
it also the
eventually
case
deported
that
or not deported.
ICE has the fingerprint data from when people are coming in? They can get, no one's stopping, am I right, that no one's stopping these people from getting convicted, doing their time in a Maryland jail or prison, and ICE can do their job and pick these people up and deport them, correct? No one is stopping this from happening. And in fact, for some of these people, we want that, right? But am I right that nothing is stopping that from happening if we pass this law?
Absolutely. You won't know who they are. You will not be able to identify the people that commit crimes that are in the country illegally.
So someone's convicted of a crime of violence. Are you telling me that ICE is unable to track the court docket and know when to pick that person up?
They may or may not.
And so I would have to wonder why they're spending so much time on all the other people if they can't figure that out. Thank you.
Thank you, Delegate Moon. All right, we're going to move around to Delegate Valentine.
Thank you, Mr. Chair. And thank you, panel, for being here today. My question kind of centered around some of the complaints of discrimination and profiling that was brought up earlier, and specifically to Sheriff Jenkins and the Lieutenant Colonel. Could you speak to that 2025 traffic stop that was referenced earlier?
If my information is correct, this individual had 6 prior encounters with law enforcement and had 2 or 3 other encounters with immigration.
So it was not just a random one-time stop?
Correct.
And to touch on the cost, I know Madam County Exec said this, but I wanted to ask Sheriff Jenkins, in Frederick County, because this was brought up last year, what is the expense in Frederick County of this program?
So this program was audited by the Frederick County Council back in 2017 because I was alleged to have been spending millions and millions of dollars on this program in county tax dollars. So an independent auditor came in, they audited the entire program. At the end of the day, now let me spell out that the training is paid for by ICE, the equipment, the technology, the language lines, transportation, all of that is paid for through ICE program money. The entire cost of our program, when you whittled it all down, listen, real close, 0.1% of staff's salary budget. Now, I would argue that people waste more time every day having coffee breaks. 0.1%. I don't have the exact dollars. I think Mike does.
The average was $8,995 a year. If everyone worked overtime, which
they don't.
It's a collateral duty inside the detention center. Nobody does this full-time, specifically does 287G. It's a collateral duty, just like a security threat group investigator, our TAC team. It's a collateral duty. The highest would be $21,421.
So you lost me. What was the $8,000 figure?
That was the overtime based on our scheduling process. This was the low number, $8,995.
And just on ballpark, what's the detention center's budget in a given year, approximately?
This year's budget, I believe, is $17 million.
So $17 million, this was about $8,000. Right.
Correct.
Okay. One last question, Mr. Chair.
Go right ahead.
And the last question I have, in addition to ICE, what other federal agencies, do you participate in agreements of sorts with other federal agencies at the Sheriff's Office?
Absolutely. The U.S. Marshal Service, Secret Service, FBI, ATF, actually even Fort Detrick we have a working agreement with. So every federal agency, we have some type of either standing or written working agreement.
Thank you. Thank you, Mr. Chair.
All right. Last two I see. I'm going to go to Delegate McComas and then come back to Delegate Congola.
Thank you, Mr. Chair. I'm going to make this real brief. There's about 81 people that signed on to this bill. Okay, all right. And I would say that probably 100% were from Montgomery, Prince George's, and the city. So my question to you is, obviously this bill is going to pass, okay? But my question is, would you guys support an amendment where each jurisdiction, each county could decide whether they want to keep the 287G? Because I know my county, with having Rachel Morin pass away, Kyla Hamilton, and the little Annie from Annie's Playground that died a long time ago. The bottom line is we've had some bad circumstances, okay? And those gentlemen, because of the way things worked, wouldn't have been dealt with by the 287G. But they had committed murders in El Salvador and stuff. Good dudes, okay? But the point I'm trying to say is, I think that there should be each community should be able to decide, and the county council should be able to decide whether we should keep it or not. And I know that Harford County would want to keep it. I suspect Cecil.
So would Frederick.
Western Maryland as well. So I mean, I think that's fair as a compromise if we can't stop this, because I think the train is on the track. So I just wanted your thoughts.
I think everybody would agree to that also. I would even propose, and I can't speak for the Maryland sheriffs, I would propose that everybody would be agreeable to pulling out the task force model as an option. Let's stick with the jail models.
Yeah, we'll tell you, Delegate McComas, that last year, the last time a survey was done, asking Maryland citizens, do you want local public safety correctional organizations to partner with federal agencies to remove criminally illegal immigrants? 76% of Marylanders said yes, absolutely.
Mr. Roby, do you feel that was that a statewide survey?
Yes, statewide survey.
So
Democrats, Republicans, Independents, all Marylanders.
Did it get broken down by jurisdictions, counties?
I don't believe it did. It got broken down by party affiliation. I don't have those numbers, but I know that if 76% of Marylanders are saying they want us to cooperate in the jails, and only when they're criminals, I think that's a significant amount of Maryland residents.
Do you know, if you know, was it weighted per the population in Montgomery? They've got a big, okay.
No.
Well, can you give us a copy of that?
Sure.
So maybe we could see that? Okay, thank you. Thank you, gentlemen. I appreciate it. I mean, my concern is we're going to lose the whole game here if we don't try to do something.
Thank you, Delegate McComas. We'll turn to Delegate Congolo.
Mr. Chair, and I just want to thank the panel. You provided very concrete data, which we did not hear from the prior panels. And, you know, what we heard earlier was less consumerism, you know, out of fear people won't go to work or go to school. And, you know, I'm not taking away from anyone's experiences here, but the reality is that policies are based on facts, not feelings. And you all provided the facts today. So I just want to just kind of point to, you know, just a question. So your data was specific to your counties, correct?
Yes, ma'am.
Okay. And how many of those people, on average, were illegal immigrants? Do you have that breakdown of all of those who were arrested?
The list I just gave you?
Yes.
100% were illegal immigrants.
I see.
And the numbers that I read off also, 100%.
100%.
Okay. Thank you.
Yes, ma'am.
Thank you, Delegate Congolo, and thank you to this panel. I want to. This is the last. Go right ahead.
I'll say, don't I get local courtesy for being from Frederick?
You get it.
All right, so this, I understand you all are talking about as specifically the law enforcement end of the police end, but this committee does not end there. We don't just talk about detaining people or when they are arrested. We are looking at the entire judicial process. And my biggest problem with, first off, I can look at your records in Frederick County, and I know not everybody in Frederick County supports it, and you know that as well, supports the 287G.
But overall, it is supported. Delegate, yes.
It is not necessarily fully supported. And here is your own stats say that 80% are misdemeanors. Only 20%, and I'm more than happy we can just talk about the 20% that aren't misdemeanors. So the way the program works is you're talking about you've charged them. They're not convicted. They're not even staying there to go through the court system. So there is nothing preventing them from really returning. Or, how is this keeping us safer? It just stops right there. So I don't find that the program is working the way you've said. And also, Sheriff, with all due respect, there are court cases in which not everyone that you've picked up has been illegal.
So I don't know what court cases you're talking about, but the two incidents that are always cited had absolutely nothing to do with the 287G program. They were actions on the street by deputies, and one goes all the way back to 2008 when the program was brand new. and my deputies were directed by ICE to pick up this woman, Roxana Santos, I think is her name, on the immigration warrant. Now, that wouldn't stand today, but back in time, 2008, that's what the instructions they were given. The other was the traffic stop, and I admitted we were wrong. I didn't even attempt to fight it. I said right out of the gate, my deputy was wrong, and yes, I apologize. And when we do something wrong, I will apologize.
As far as the.
Okay, so this 20% that you have, or the one individual who's murdered or killed, what happens? So they're just picking them up. ICE is picking them up from the detention center. Are they ever brought to the courts to be convicted and then sentenced and serving their sentence?
As far as the ratio of misdemeanors to felonies, a vast majority of the charges in Maryland are misdemeanors. Domestic violence is a misdemeanor. Up until about 5 years ago, I could be wrong, I'm getting older, assault on a police officer was only a misdemeanor. So the vast majority of criminal charges in Maryland are misdemeanors.
This committee is aware of that.
Okay, I was
Okay?
answering your question, ma'am.
That is definitely what, but we are also talking about charges.
Okay,
We are not talking about convictions. And once again, this committee does not stop at the charges. We want to make sure that the people who are actually committing crimes are held accountable and that our streets and our communities are safer. So you're saying that this keeps our community safer by taking individuals who may or may not have actually committed any crime, who may or may not actually be here legally, who may have recently, now they've had their immigration status changed. All of these things, as far as our families, you just want us to ignore all the people who come. I live in that community. I live on the Golden Mile. Okay, I meet the families that you have deported these individuals before they've ever been convicted of anything. And they have 10 families who had newborns, or they were about ready to give birth, and their family members were deported before it was completely determined that they even were here legally, illegally, whatever you want to call it, you know, or if they had the proper documentation. So is this really keeping us safer?
Yes.
Yes.
Every case is adjudicated one way or another, and every
Adjudicated is
individual
not a
has due
conviction.
process at both the local and the federal level.
That's
Well, and
not
I
a
think the thing to
conviction.
remember too, ma'am, and with all due respect, first of all, not one person on this panel has ever deported anyone. We've not deported not one person up here. But we are the people up here are willing to work with the federal agency to make our county safer. And every single one of these individuals, I keep hearing you say they haven't committed a crime or they might, ma'am, they broke immigration law. That is a crime. I know the previous federal administration did not think of it as a crime, but this administration does. Whether we like it or not, I have to work. Look, as a Republican, I do a great job at reaching across the aisle with the Democratic Party here in Annapolis. But I also have to work with the federal government as well. So whether we like Donald Trump, whether we like the Trump policy, whether we like ICE, they are here. Please don't take away the only thing we have to work with this federal agency. That's what we're asking.
Several of these individuals are individuals who here had documentation and were here legally, and that status was changed.
By the federal government, not by Julie Giordano, not by the sheriffs up here, by the federal government. We have no control over that. So the things that we can control, the only things that we can control, you're getting ready to vote to take that away. That's what you're getting ready to do. The only thing that we can control.
So my question is, it's a yes or no.
Sure.
These people are being transferred to ICE before an actual conviction. They were convicted of the crime that they're charged with. Is that true?
So if they're being transferred to ICE, ICE has made a decision on their priority list whether they want that individual or not. It's not a yes or no answer, honestly.
It is a yes or no.
No, it's not.
Have
With all
they
due
been
respect.
convicted of the crime they're charged before they are transferred?
I think that's a fair question.
It's not a yes or no answer, though. It's the decision by, ICE is making that decision based on their priority list. They're making decisions based on national security. They're making decisions based on crimes that they have committed in other countries, much like Victor Hernandez, who killed Rachel Morin.
Have they been convicted of the crimes they're charged with?
Many have, yes.
Are they convicted of the crimes they're charged with, that they are in your custody?
Many have, yes.
So the answer is, so I want to be clear on the answer. The answer is some have and some have not.
That is correct.
Okay, thank you.
That is correct.
Mr. Chairman, the appropriate term would be cases adjudicated. That would be an appropriate term.
And you indicated that the cases were adjudicated, but in some instances, there's been no trial, and so there's been no determination of criminality, right?
Due process.
Right, correct? There's been no final determination of criminality of Maryland state law.
Correct, due process for the Maryland charge that they're facing, but that individual will still have to
Thank
face
you.
due
That
process
was my question.
going through an immigration hearing.
Understood. I've got a question, and then we're going to wrap this up. So I want to thank you all for coming in. You're holding on to this, and there are about 6 counties, right? But out of that, more counties that do not have a 287G program. And those counties aren't coming in making the same argument for why they need a program. So I would like to know, what is the distinction between your counties and the other counties, and this idea that ICE is coming? My sense is ICE is coming with or without 287G. That's my opinion. But what is the difference between your counties and the other counties that don't have it?
Mr. Acting Chair, the only thing that I'll say to that is we made the decision, Sheriff Gaylor made that decision in Harford County based solely on a public safety decision for the residents of our county. Now, I can tell you that the counties of Baltimore County and the counties of even Montgomery County. Montgomery County, there's a big story about a year ago where they made a decision to enter into an agreement, an MOU with the Immigrations and Customs Enforcement. Now, they do not go as far as the 287G jail model goes or the warrant service officer model goes, but they still have entered into a partnership and into an agreement because they realized they were getting dangerous criminal gang members in Montgomery County that were creating havoc for their communities. So they made the decision to enter into that agreement because they don't want these individuals terrorizing their communities.
Thank you. Well, I want to thank you all for coming in. I think we've heard from both sides of this particular bill, HB 444. I want to thank the members of the committee who stuck with us today. This is our last panel of the day. And once again, thank you for having patience with me and with Delegate Embry. So thank you all very much. Have a wonderful evening. Okay.
We're done with this one now.
I thought we were done.
And I gotta get clear.
I'm sorry. So you all get to leave. Thank you for the sponsor of the bill. Thank you to Delegate Williams. All right, calling House Bill 171 with Delegate Valentine. If I could ask those that are leaving the room to leave quietly. Thank you very much. Man, I was ready to get out of here. Thank you. And Delegate Valentine, on your panel, I see Merritt Williamson, Chad Atkins, Jonathan Holler, Matias Cachiro. The good delegate from Western Maryland, we're ready when you are.
Thank you, Mr. Chair. Actually, good evening. Mr. Chair, members of the House Judiciary Committee, for the record, Delegate William Valentine, District 2A, representing both Washington and Frederick counties. I'm before the committee today to present House Bill 171, Criminal Law, Drug Trafficking Crime Definitions. CL 5-621 criminalizes the use of a firearm in a drug trafficking crime. The policy reason for criminalizing this behavior, in addition to the drug trafficking crime itself, is reasonable. The presence of a firearm in a drug transaction dramatically escalates both the probability of violence as well as the level of violence should it occur. This conduct is particularly harmful to communities, and not insignificant percentage of gun violence is at least somewhat related to drugs. And as a result, it's tearing Maryland communities apart. After the possession of recreational use of cannabis in certain amounts was legalized under Maryland law, cannabis offenses that used to be felonies became misdemeanors. While this change makes sense, one unintended consequence was to render individuals who engage in drug trafficking offenses involving cannabis while using guns ineligible for prosecution under the statute. What this means is that an individual illegally distributing cocaine while using a gun is subject to this offense, but an individual illegally distributing cannabis while using a gun is not, despite the threat posed by a firearm is exactly the same. HB 171 remedies this issue, restoring the ability to prosecute those who engage in a drug trafficking crime involving cannabis while using a firearm, without increasing the penalties for a cannabis-related drug trafficking crime at all. HB 171 is a narrowly targeted bill that closes a loophole that currently allows some individuals to engage in illicit drug distribution to escape criminal liability for using a firearm, and restores this important tool to help Maryland's prosecutors build safer communities. In closing, I would respectfully request a favorable report. Thank you, Mr. Chair.
Thank you, Delegate Valentine. Mr. Williamson.
Yes, good afternoon.
Ms. Williamson, I'm sorry.
It's okay. My name is Moreau Williamson. I'm an assistant state's attorney here in Anne Arundel County, Maryland. I've been a prosecutor for 18 years, and for the last 11 years, I've been assigned to the Felony Narcotics Unit. Here in Anne Arundel County, I handle drug, gun, and homicide cases. I am testifying today on behalf of the Maryland State's Attorneys Association. The purpose of HB 171 is simple: to bring possession with the intent to distribute cannabis and manufacturing cannabis with the intent to sell back into the definition of drug trafficking with a firearm. Previously, these two crimes fell within the definition, which applies specifically to drug felonies. Since the time that these two crimes have been made misdemeanors, a loophole has been created in the law. We are not talking about cannabis users. We are not talking about cannabis that people buy within the current regulatory framework here in Maryland. We are talking about people who sell cannabis with a gun. Dealing or manufacturing drugs with a firearm creates a dangerous situation, no matter what particular substance is being sold. A gun used in connection with a drug transaction has the potential to be deadly, whether someone is selling PCP, cannabis, or oxycodone. I've personally handled a murder which involved a cannabis transaction where two firearms were fired, one on the seller's side and one on the buyer's side. As an example, in Montgomery County, as of last year, there were 18 cannabis-related murders in the past 3 to 4 years. Cannabis being sold on the street remains a valuable illegal commodity, and people will take measures to protect it or to enforce a debt. On the street, cannabis is sold for $100 to $150 an ounce and can go from $2,400 to $3,200 a pound based on the quality. Based on the violence that comes from selling drugs with a firearm, no matter what the substance is, I urge a favorable report of HB 171.
Mr. Chair, good evening, everybody. This is my first time testifying to anything, so bear with me. My name is Chad Adkins. I'm a lieutenant with the Frederick County Sheriff's Office in Maryland. Currently, I oversee the Narcotics Investigations Section. I spent my whole career, over 2 decades, in law enforcement as a deputy out enforcing laws, and then as a canine handler. I was intricately intricately involved in the narcotics realm, like apprehending narcotics traffickers on the highways, stuff like that. Now I found myself in a command position. I'm here to tell you right now, the market for illegal marijuana sales, illicit marijuana sales, is thriving, it's profitable, and it's violent. It's just the reality of what we're dealing with, what my narcotics unit is dealing with right now. I know that, our government, when I look at this bill and what it would do, I know our government and its laws are designed to work in a balance, with checks and balances. And I do believe this bill kind of bridges that gap. This bill specifically and individually targets these crimes of these narcotics traffickers with a firearm, while at the same time balancing Maryland's intent with the deregulation and the legalization of marijuana. We're not asking to go out after those people. It's a common sense bill. I brought 2 examples. I know I have 30 seconds left. I'm going to try to get through them, but these 2 examples are where this bill would have actually been beneficial to law enforcement. On March 6, 2025, patrol deputies observed what they believed a hand-to-hand drug transaction at a gas station. They developed probable cause on the vehicle. They stopped it. When they approached the vehicle, the individual had a HQL and a handgun. However, a PC search of a probable cause search of the vehicle yielded approximately 3/4 of a pound of marijuana, $1,200 cash, a digital scale, prescription codeine, and a Glock handgun, magazine inserted, round in the chamber. The individual was seen selling marijuana, and he's got an HQL, and he's legally allowed to possess this firearm. So this loophole allows this drug distributor to.
Thank you.
Sorry.
No, it's fine.
On the clock.
And I'm sure someone's going to ask you a question, so we'll get there.
Okay.
All right.
Thank you.
All right. Was Jonathan Holler with us? Or Matias Cachero? Matias? All right, we'll bring Matias on.
Unable to meet it.
All right. Hello. Good
Jonathan's
afternoon.
not able to be here. We'll bring Matias on.
Hello. Can you hear me?
Yes.
Okay. All right. Good afternoon, Acting Chair Phillips and members of the committee. Thank you to the committee and staff for accommodating my testimony online. And thank you to Delegate Valentine for reintroducing this important legislation. My name is Matias Cachero, and I'm the Deputy Director of Government Affairs for the Office of the State's Attorney for Baltimore City. I have submitted written testimony highlighting some arguments in favor of this legislation. So for my oral testimony today, I want to focus on additional considerations for the committee. Since Maryland officially legalized recreational cannabis in 2023, the industry has made over $1 billion in sales and has generated over $73 million in tax revenue for the state. At the same time, it is important to acknowledge that cannabis prohibition in this country has long been intertwined with racial stereotyping and discriminatory enforcement practices. Legalization was intended in part to address those historic inequities and reduce unnecessary criminal justice involvement for low-level cannabis use. House Bill 171 does not reverse those gains, nor does it recriminalize recreational cannabis use. This bill is about addressing gun violence and holding accountable people who are not casual smokers and tokers, individuals who operate outside the regulated market at a large scale, and whose illicit activity is directly linked to public safety risks, including gun violence. I would like to show the committee a picture here on my iPad of, hopefully you can see with the lighting. If not, I can submit it to the committee. You can't really see it, but it's essentially over 30 pounds of cannabis and over 8 firearms. And although the firearms were legally registered, the police investigation found that the cannabis and the firearms were in close enough proximity to each other to indicate that this individual was using these firearms in protection of a drug trafficking crime. However, misdemeanor charges or a conspiracy to commit a misdemeanor in violation of the statutes listed in this bill are not part of a definition of drug trafficking crime, and that is what this bill seeks to address. And this individual is only charged with CDS possession of cannabis. Thank you for your time, and I urge a favorable report on House Bill 171.
Thank you, Mr. Cachero. All right, questions. We'll start. You know what? I'm going to go to the right side of my right today, and I'll go with Delegate Simmons.
Thank you, Mr. Chair. And Lieutenant, I just wanted you to continue giving an example of
some of the examples that you was given pertaining to cases involving marijuana and weapons.
Thank you, sir. I just had one more. I think I plowed through the one. The other one, October of this past year, deputies had a traffic violation, pulled a car over. This individual ended up being a known associate of gang members, a gang in Frederick County known as PA 32. This individual was actually a recent victim, believe it or not, of a shooting where other gang members were shot at a bar in Washington County. We have a K-9 respond to the scene. The trained narcotics dog alerts to the vehicle, and a search of this vehicle revealed a black bag on the front passenger seat. And in that bag were candy-style marijuana packaged from a dispensary. So you have your dispensary marijuana, which is fine, half an oxycodone prescription pill, and an allergy bottle. And additionally, outside of that bag was another pound, which well goes over any kind of legal standard of marijuana. There's a pound in this car. In the bag was also a Springfield Armory Hellcat 9mm with a 15-round magazine inserted in the gun with a round racked in the chamber. Like, all you have to do is pull the trigger and that gun's gonna fire. He was taken to jail for the marijuana offense, but we checked with the Maryland Gun Center, and he had an active concealed carry permit and an HQL license. So he was legally allowed to have that firearm by Maryland law. However, he had a pound of marijuana in his car, and every indication that he possibly could have been selling. This legislation would have helped in that. I mean, we ended up returning, as far as I know, once it's adjudicated in court, we'll have to return that firearm back to this individual. That was the other example that I had.
Thank you. Do you have a follow-up, Delegate Stinnett?
Yes, thank you, Mr. Chair. What other risks are associated with the sale of cannabis and, amongst the illegal market?
Right, so I can jump in beyond the violence that we've talked about, which I can also talk about some more. There are a lot of risks of buying cannabis in general on the street. People don't know what they're buying. They don't know what's in it. Is it laced with PCP? What is the THC level? Ideally, people are going to the dispensaries. However, that's just not happening. There's been a lot of street activity with cannabis, particularly with the decriminalization, with the lowering of penalties. People know they're really not going to get much of a penalty for selling cannabis on the street, and it's just exploding. If you talk to law enforcement in any part of the state, they will tell you that as the witness said, the business is thriving, and there's so much violence associated with it. In particular, a couple more examples from Frederick County were provided. There were 2 separate home invasions that were provided as examples. One in 2023, a number of people went to a home to collect on a debt for cannabis. They were going to find $40,000 of cannabis proceeds. They were armed with handguns, long guns, and machine guns. In another situation in 2025, there was another home invasion in Frederick County. It turned into a shootout. One of the suspects who went to the home actually ended up getting shot. One of the people came with a handgun. One of the people came with an AK-47, and about 30 pounds of cannabis was recovered from the home. The bottom line is that drug violence is drug violence, and it does not matter what substance is being sold, and that's why we are seeking to reincorporate. This is not a new law. It's just reincorporating cannabis, possession with intent, and manufacturing back into drug trafficking with a firearm. The only reason it's not included anymore is because it is now classified as a misdemeanor, and 5621 specifically says a drug felony or a conspiracy to commit a drug felony. We are not seeking to create new law. We are seeking to close a loophole.
Thank you.
Thank you, Delegate Clark.
Thank you, Mr. Chair. Thank you guys very much for being here. Thanks for the bill. So going back, I just want to follow up on that comment. Thank you very much for that. So these pop-ups, and maybe, I don't know if the gentleman from the state's attorney from Baltimore City is still available, but if he is, that I can talk to maybe the state's attorney from Anne Arundel County instead. CDS, what's the maximum penalty for PWID CDS?
For cannabis,
Yes.
3 years.
3 years. And if they have 30 pounds, it's still 3 years?
It's still 3 years. Volume dealer is over 50 pounds. That has actually been changed to a misdemeanor. That's a 10-year misdemeanor.
10 years, okay.
Correct.
And there's no laws right now that prohibit somebody who's licensed to be able to carry a gun to carry it chambered into other people's residences and creating some sort of public safety issue? Are there any crimes there that we can?
There are laws that address that
Okay,
Well,
so those could be charged as well, I'm just making sure.
in that way. However, if someone is driving down the road with their loaded handgun and they have a dealer amount of cannabis in their car with them, they could be charged with possession of a handgun in a vehicle or possession of a loaded handgun in a vehicle. Those are 5-year misdemeanors, and they could be subject to the 3-year misdemeanor of possession with the intent to distribute cannabis, but they would no longer be subject to drug trafficking with a firearm.
Got it, okay. And then the last question is, so these pop-ups that were mentioned by the state's attorney from Baltimore City that are popping up particularly all over the city, these illegal marijuana shops. If this bill were to actually pass and they have a gun in a shop that's illegally distributing marijuana without a state license, then they would be subject to this penalty, would they not? Even if they had a legal gun or a person, a security guard with a loaded gun.
So when you're saying pop-up, do you mean outside the regulatory scheme or within the regulatory scheme?
Outside of the, so a smoke shop that's now selling marijuana didn't get a license, so it's outside the regulatory scheme.
So that if they are selling drugs, well, that would be distribution, which actually still is a felony. So yes, they would 100% under the current law. If you
Cannabis.
Yeah, if someone is distributing cannabis, that is still a felony. So someone who sells a little bag of cannabis to someone else with a gun in their pocket is subject to drug trafficking with a firearm. Someone who is sitting on 30 pounds of marijuana and has not made a deal yet, or the police did not see them make a deal, is not subject to this law. But it is just a big loophole.
Okay, great, thank you.
Okay, Delegate Conaway.
Thank you, Chair. Thank you, Delegate, and people come out to testify today. So I wanted to ask you, the question is, Delegate Simmons still on this bill? Delegate Valentine?
That is correct.
Okay, and the bill says, or bracket cultivating or growing cannabis bracket. Would this apply to a homeowner or a tenant that is growing 3 or more plants and has a conceal and carry permit?
So the police would have to determine that the person was manufacturing with the intent to sell. So just because
I think 3 plants is illegal, right?
2 is the max.
Right, 3 plants is illegal. And my second question was going to be, what about if a person has a long gun instead of the handgun? Would that cause a violation? And then he had the 3 plants.
Right, a firearm is, yes, a firearm account is a firearm, the long gun. However, just because someone has 3 plants does not mean they're going to be prosecuted with manufacturing with the intent to sell. The police would have to take a look at that. There'd have to be determination. I, as a prosecutor, unless I 100% knew and there was evidence that this person was actually selling, would not use my time, and I would use prosecutorial discretion and not proceed on that case, because that just does not make any sense at all.
Well, when this bill passed, law enforcement were talking about flying over people's backyards using drones to see if they had more than 2 plants, because you needed a male and a female or 2 females or something. So I'm just going on testimony that I previously heard. But I thank you very much.
Thank you, Delegate Conaway. Delegate Taylor.
Thank you, Mr. Chair, and thank you for being here. I'm trying to figure out the best way to ask this question. Hey, do you have data that says that drug violence has increased since marijuana has been decriminalized?
I don't have data. I have plenty of anecdotal evidence, which I can share with you. I know that there are plenty of shootings that regularly occur over the sale of cannabis. I was talking to an officer the other day, and he said there's a particular area in Glen Burnie, it's an open-air drug market, plenty of cannabis sales. Everybody is not, everybody, many people are selling cannabis. It's widely available, low penalty. And there are a lot of shootings with regard to territory, clientele. They're fighting over the territory. I was just speaking to someone, and they commented about the daily shooting brief that comes out every day by law enforcement, and particularly in Baltimore City, there are many shootings that happen over the sale of cannabis.
And these shootings probably happened in these situations were probably as prevalent or even more prevalent when marijuana was criminalized, potentially.
I don't have those particular numbers. I can tell you that I have a colleague who was supposed to start a murder trial yesterday, but it hasn't started yet because of the weather. That happened here in this county, and it was a sale of cannabis, and the people decided to set them up and actually rob the drug dealers of their cannabis, and it turned into a homicide. It is a widely available substance on the street, and people are going to take measures to protect it.
Understood. And for the sheriff, do you mind if I ask another question?
Go right ahead, Delegate.
There was, I think you said it was a young man in a car. He had a pound of marijuana and a Glock. The Glock was lawful. If he was a known drug dealer, would a background check have prevented him from being licensed to get that gun in the first place?
No, so I'm not with the licensing division. I can just tell you as a gun owner myself and how I see, because when I had these particular examples, I called down to the Maryland Gun Center, which is ran by the Maryland State Police, to ask them, like, I'm trying to figure out, how did this even happen?
Right.
I've talked to some federal counterparts that I have. On the federal form for the ATF that you fill out for any kind of weapon, it asks if you're a habitual marijuana user or habitual drug user, but there's no verification whether that person is. It's basically an honesty system. They can check whatever they want to in the box.
No background check.
And it takes from what I gather from Maryland State Police, when I talk to them, if I remember my conversation correctly, it has to be a conviction on a prior drug crime that would actually cause that person to be prohibited at that point.
Sure.
Both of those individuals, though, what is kind of interesting is those guns, neither one was registered, so it wasn't purchased in Maryland. I believe if you purchase a gun in Maryland, it's got to go through a certain system, and there's that 7-day waiting period and all that stuff. This was never registered. When we ran a gun check to this individual and their name, that gun didn't pop up, and if it didn't pop up, and if it was registered, it would have. So it's an unregistered firearm, but it's not a crime according to Maryland
Just one
law.
more question, follow-up. And if this bill passes, you had the same situation, tell me what would happen to that individually. How would he or she be charged?
They would be charged with trafficking, drug trafficking with a firearm. Right now, we couldn't charge any of that. The best that we could do was PWID, possession with intent to distribute marijuana, and nothing with the gun thing. And PWID marijuana is a misdemeanor now, which is fine, but logically speaking, in the spirit of like what the law was designed, I have a hard time wrapping my head around why we would arm, no matter what kind of narcotic anybody's dealing, what our stance is. If you want to legalize marijuana to an extent, good, that's fine. I'm not here to infringe on anybody's right. But when we have somebody engaging in the criminal sales and I can't charge them when they have a firearm, luckily they didn't pull it on somebody or the officer that's approaching this traffic stop in the middle of the night. Luckily everything went well, but I couldn't wrap my mind around why that was okay. Why can this person distribute drugs illegally and have a gun, and there's absolutely nothing I can do about it?
Thank you.
And I'm going to come to,
I'm
good, Delegate Taylor. I'll come to you, Delegate Ericon. I want to be clear on something. Is there a legal threshold for possession with intent to distribute?
That's an interesting question, because the jury instruction says there is no magic number where possession with intent appears or disappears. It has to do with all the factors surrounding the situation. So does someone have multiple packages ready for sales? Do they have bulk amounts of, whatever the substance is to sell? Or is there packaging material? Is there money? Is there a phone with text messages? They talk about drug ledgers. Everything's on the phone now. I love when we can find a sheet of paper with people's names and numbers. Doesn't happen as much anymore, but names and numbers of customers. Maybe the police officers have been watching the person and they did a search warrant and they have other evidence of drug activity. So to answer your question, there's no magic number, but it has to be on the totality of the circumstances. And to give you an idea of the kind of cases that we're talking about where this would apply, I can give you an example. I had a case that occurred in 2022, but it went to trial in 2023. So the law had changed, so we could not use drug trafficking with a firearm because that penalty was no longer in effect. And the person had $30,000, about 15 pounds of cannabis in their house, and a handgun with 2 magazines. And this law did not apply. Drug trafficking with a firearm did not apply. Recently, there was a search warrant executed here in Anne Arundel County. There were 450 grams of cannabis and a rifle. That would not apply. Drug trafficking with a firearm regarding cannabis would not apply to that crime. We are talking about large dealer amounts of cannabis with a firearm.
Would it make sense for us to set a threshold?
If someone is clearly dealing, even a smaller amount, they're still dealing. And for no other drug is there a particular amount that's set. It's a question for the jury or the finder of fact.
Thank you. Delegate Erica.
Thank you, Mr. Chair. Thank you for being here. Sir, you did very good on your first day of testimony. I'm just trying to understand exactly what happened in this one traffic stop. So you called into the, the gun center to find out if the firearm or if the firearm owner was lawful. So, okay, HQL, you can own a firearm. You cannot travel with a firearm loaded. So that's at least one crime we could get here. Hopefully whoever that is for is okay.
That individual had both, though.
Okay, so
HQL and.
Oh, he also did have a wear and carry.
Yeah.
Okay, so he had a wear and carry. Okay, so he was allowed to carry a loaded firearm. Okay, but and you called the center, but okay, the thing about the center is that there's no real such thing as registered firearms. When we go to purchase a firearm, it goes through that system. They'll have a record that we bought a firearm, not that it is registered to us necessarily. Okay. So they could have moved in from out of state or bought it out of state lawfully, but it didn't go through our system here. So that probably wasn't, it could have been a legal firearm, but probably was lawfully owned. Okay, so there was no way then for you to charge him because he had checked off all of these boxes, but he had how much marijuana with him?
Pound.
A pound of marijuana.
Both of these cases that I brought, like the first one, for an example, was 3/4 of a pound. Your threshold, is 1.5 ounces for legal, and then it's up to 2.5 ounces for just a civil penalty, like no criminal. We're talking about 3/4 of a pound, and then the other is a full pound.
So it's obvious armed drug dealing, and we can't charge them appropriately. So this is I don't think the intent of when we crafted this law. I do not believe this was the intent. I don't think anybody in this room thinks armed drug dealing should not be a multiple charge thing. So thank you. Thanks for helping me understand how that happened.
Yeah, what happened was, in my opinion, is it went from the wording for drug trafficking, now the way the law is written, not in the senator, on his bill, but currently it says it has to.
You did a good job, sir.
The one that's currently in place, it says it has to be a felony. Well, P-Wood marijuana isn't a felony offense, which is fine. So this is amending that bill to say, hey, that's okay, we're not trying to change the law on what marijuana the sentence is or the misdemeanor felony. We just want it to be able to charge for the firearm when somebody's dealing marijuana.
Very reasonable. Yeah, I hope you'll come back to fix why it always smells like pot in the tunnel now.
Yeah.
Thank you. I think this ends the favorable testimony for Delegate Valentine's Bill 171. And I believe we have a couple of unfavorables. I'm not sure if they're here. I'm going to step away for a moment. If Delegate Andrews will take.
think we're excused.
Thank you.
Is Rusty Carr here? Please come up, sir. Thank you, Mr. Carr, for your patience. If you'd like to speak to us for 2 minutes, thank you.
Here we go. Thank you, Madam Chair, members of the committee. My name is Rusty Carr. I am a resident of Mount Airy, District 4. Don't see Mr. Pippi here. Simpson, thank you, Frederick. I am a current medical cannabis patient. I am a caregiver. I am an activist representing the cannabis community, but I am not representing any organization at this moment. I'm also a home grower, and I can tell you that I grew a little bit more than a pound of cannabis this year, and it is sitting in my home, and it is for my own personal use. I am not dealing. I do not sell cannabis. I will note that Maryland sells 3,500 pounds of cannabis per month to non-residents of the state of Maryland. The largest dealer of cannabis, of illegal cannabis in Maryland, is the state of Maryland, because we allow sales to non-residents that presumably goes over the border to other states. There's been a effort to close down tobacco shops, illegal sales. Hasn't worked very well. They just took off the THC off the package, and they're still selling the same stuff. I've bought THCA flower from Snoop Dogg. It's unlicensed. It's delivered to my home. I've bought illegal cannabis from licensed vendors. Wana has a license to produce cannabis in Maryland. They will ship illegal products to my home. I've got them in the fridge. Beverages, same thing. Yes, cannabis is widespread. Unlicensed cannabis is widespread. Guns is not the problem. It's the licensing. I'm free to answer any questions. Thank you.
Thank you very much. Colleagues, any questions? Oh, yes, Delegate Erica.
Thank you so much. Thank you for coming here. I just have a couple quick questions. Do you own a firearm by any chance?
I do not.
Okay, I was going to say, do you ever travel with the full amount that you've grown in the last year in your vehicle?
No.
Okay, all right, thank you.
Thank you. I think that concludes the testimony for House Bill 171. Delegate Cardin, if you don't mind, we will hear testimony on House Bill 180. And Delegate, who, if you'd like to bring anyone up? Oh,
Yeah, I have
Ms. Varda,
two
hello.
people on my panel, and one is supposed to be online. Is he still on there? Oh, thanks. Awesome. Let's see.
Mr. Turner, I see, okay?
Yes.
Hi.
I think I'm the last one of the day.
You are.
Okay.
Congratulations. All right.
Madam
take
Chair,
it away.
it's a pleasure to see you, Madam Chair. For the record, I'm John Cardin. I am here on behalf of House Bill 180 and Competency Stand Trial. My panel is going to be Tracy Varda from the Baltimore City State's Attorney's Office, as well as Mr. Troy Turner, who's online. He was not able to make it through the cold and the snow. House Bill 180 has been in front of this committee year after year. We have worked hard on this legislation, and it got out of the Senate last year. It didn't get out of the House. We see to flip-flop that every year. House Bill 180 seeks to alter the time period after which a court is required to dismiss a certain charge against a defendant found incompetent to stand trial under specific circumstances. Why are they incompetent? We can go into that later if you want to ask questions. It also requires the court to provide notice and to offer an opportunity to be heard for the state's attorney and the victim or the victim's representative before dismissing the charge against the defendant found incompetent to stand trial. Currently, there's a provision requiring the dismissal of charges after 5 years if the defendant is found incompetent to stand trial, and that's the operative issue. Prior to 2012, the time period was 10 years. This was a result of amendments made with interest groups involved that came up with this, the Public Defender's Office, the Disability Law Center, the State's Attorney's Office, all the stakeholders were involved, and they determined that 10 years was the appropriate amount. And then 2012 came, Delegate McComas, Delegate Conaway, and I think we're the only 3 people here that were able to vote for the elimination of the death penalty here. I think that 2 of us actually voted in favor of it. I know I did. At that time, because of an error or an oversight or an unintended consequence, the law was changed so it went from 10 years to 5 years. This was inadvertent. This was not intentional. Let me make that clear. The intent and the agreement of all the parties was to keep it at 10 years. And you're going to hear why from Mr. Turner in a few minutes. That House Bill 180 seeks to modify the timeline, change it back to the way it used to be, so that those defendants charged with first-degree murder or first-degree rape who are incompetent to stand trial will not be released in time to hurt people that they have intended to hurt and said that they were going to hurt. This ensures the legal process moves forward in a timely manner while respecting complexities of cases involving defendants who are unable to stand trial due to incompetency. There are 2 amendments I've already given to Claire that I can explain if you want, but we can do that in subcommittee if we want to. In conclusion, it's an important piece of legislation that really does look out for the interest of justice and the rights of victims. There were 3 comments made by the Disability Rights Maryland in the Senate earlier today. Those comments, I think, were unintentionally inaccurate, completely inaccurate. And if you want to ask, Ms. Varda can probably answer it better than I can, but that may be something that you want to ask about so that we can preempt any inaccuracies coming forward.
Thank you, Delegate. Ms. Varda?
Good afternoon. I have been handling Baltimore City State's Attorney's Office Mental Health Court for the last 15 years, and for that reason, I know from firsthand experience how important this bill is. Currently, when an incompetent defendant is charged with first-degree murder or first-degree rape, the court's required to dismiss the charges after 5 years if the defendant has not become competent. This bill will allow additional time to treat and restore these defendants to competency. This bill will not violate the constitutional rights of the defendants. Every 6 months, they will be reevaluated, and if it's determined they cannot be made competent, the charges will be immediately dismissed. The judge retains the right to dismiss the charge at any time, and it's a very narrow bill, applies to a very small population, but an extremely dangerous population. What the bill will do, it gives the court the option to hold the charges open for up to 10 years. It will not require the courts to do that. In order for the courts to hold the charges open, the defendant must meet 3 criteria: must be charged with first-degree murder or rape, has to be deemed dangerous, and the defendant's doctor must say that with additional time, we can find this defendant, we can restore this defendant to competency. In a minority of cases, it does take longer than 5 years to make somebody competent. Sometimes it takes that long to find the right medication combination. Sometimes medications just stop working after a while, and sometimes defendants don't cooperate, and that makes the process longer. This bill will protect public safety, especially for our most vulnerable citizens. In my experience, especially with the rape cases, the vast majority of victims are those with disabilities or children because they are easy targets. This bill will allow defendants more time to receive services which benefit them and also mitigates their risk to public safety. I submitted written testimony that explains the necessity of this bill because I cannot in 2 minutes tell you all the reasons why this bill needs to pass. But for these reasons, and on behalf of the Maryland State's Attorneys Association, we urge a favorable report on this House bill. Thank you.
Thank you very much. Mr. Turner? Oh, you need to unmute yourself.
You gotta unmute yourself.
There we go.
There you go.
Well, first is thanks for letting me speak again. I'm not sure, who's been there before, who's new, so I'll briefly just cover my story. Uh, my two youngest children, Sarah and Jacob, at 2 and 3 years old, were murdered by their biological mother. We have been fighting to find my kids first and foremost, and secondly for justice for 11 years now, over 11 years, almost 12. A big part of that has been that she was found incompetent in the beginning, and it was carried on. Part of the issue was that there's a secondary gain to 5 years whenever you're looking at longer time. Part of the issue is that it was stated in court that they don't treat people really other than just group therapy while they are facing charges. So finally, after 5 years with the felony charge, the charges were dropped. People, I've heard them say things like, she would be in for at least 20 years. She'd be held for 30 years. She'd be held for some indefinite amount of time. I had said at the time she'd probably be out within a year, definitely within 3. In less than 6 months, she was shifted to a voluntary commitment and was able to basically request to be out and got out. A few months later, she requested to go back because of her anxiety. And then she was released again. And before 3 years was even up, she was released with 0 conditions, no medication checks, no nothing. She was followed by the police shopping at Target. And she was released into a small community on the Eastern Shore where there was a lot of elderly people who were retired. There was a lot of families with small children. And not my words, but their words were, they were very upset when she was arrested because they felt that a monster was released into their community without them being notified even. As far as just really quick, if you don't mind, I'll just say this. There's certain things that are in place that are statute law where I'm supposed to be notified if certain things happen with her. Death, released, or moved facilities. She was released on July 9th. It wasn't until July 23rd that they actually even let me know that she was out. And there was actual kind of, it was semantics played in terms of if she was still there or not.
Mr.
So-
Turner, thank you so much. I'm sure
Yeah.
someone will ask a question so that you can complete.
I would just like to say it's
Thank
about
you.
public safety.
Thank you so much. That concludes the favorable testimony. Do we have questions? Delegate Erickson.
Thank you, Madam Chair. So thanks for the bill, and I'm so sorry for the loss of your children, sir. I know everyone in the room feels the same way.
Thank you.
How was she, so explain how the process works. How was she not then retried? So if she was found competent eventually and released, how was she not then retried? Isn't that how it's supposed to work?
So,
No, not really. I can answer this actually just because I've been through it. So you'll hear people, saying that how it works is the 2 prongs and it's a very low bar and all that. It's really not. It depends on the judge on where the bar is actually set for the second prong. So and what happens is, once she's found incompetent, you have to prove beyond a reasonable doubt that she is competent. So now you're talking about like a 96 or 97 percentile or more?
Right.
So at that point, so people will say like I don't want to say people fake it or whatever, but there's a blueprint pretty much that has been laid out to choose to be incompetent. So it's not denying mental issues or saying that people don't need help. And I think that's a part of the issue as well, as far as the public safety goes. There's no justice in any of this. You have people who really want the help and deserve the help who aren't getting it because there's charges pressed. And Perkins has said, their doctors, Dr. Brown said in court on record, we don't treat them because we don't want to bring them to a competency. They may go to jail.
Oh, my gosh.
I looked it up. They're getting almost
Mr.
$100
Turner,
million a year to bring people to competency. So I'm confused by that.
Mr. Turner, let's let Ms. Varda also talk from the legal perspective.
No problem.
Thank you, sir.
There's a couple things I want to follow up on. One thing that Mr. Turner said about Dr. Brown saying they don't receive treatment in the hospital, I understand that that's one case, but I have been doing this for 15 years, and I don't know, I can't speak specifically to that case, but I can tell you all the cases that I've had in 15 years where the defendants have been in the hospital to get restored to competency, they are getting treatment. They're getting medicated. That's the whole reason why they're in the hospital, is to have their mental illness stabilized so they can be found competent. So I'm not sure what happened there, but the defendants are receiving services. But to answer your question, legal-wise, the statute allows the state to recharge. So somebody's incompetent, the 5-year mark comes, the charges get dismissed because the defendant's not competent. The state can recharge, but that is not nearly as easy as it sounds for several reasons. First, the burden shifts. So the burden has, if the charges are dismissed, then the state has the burden of showing that this person is restorable to competency, and that's not a burden the state has ever carried before. But the biggest problems are, one, when the defendant is dismissed, they're released onto the streets. People with mental illness or people with intellectual disabilities, those are the two type of populations that are found in competent stand trial. Many of them are transient. So if they're released on the street, we may never see them again. The other problem is they're released, so all the treatment that they've been getting, now there's a break in treatment. And it's taken us this long to try to get them competent. And remember, with this bill, the doctors are saying, we believe it's likely this person will still be competent. But if they're released, now there's a break in that treatment. And the other problem is, and as Mr. Turner said, they are now in the community with no supervision, nobody telling them they have to take their medication or get treatment. So it's a tremendous public safety risk to dismiss this case and then put it on the state to recharge the matter.
So there's no probation, nothing like that, because they've never been found guilty?
They walk out the door.
Okay. How many people is this? Like, what are we talking about?
Tiny population, that's the thing.
Okay, so it's small. So
It's just, that's what I'm saying. It's a small population, so it's not going to apply to a lot of people, but it will apply to our most dangerous. And I just want to give the example. I had a defendant, horrific homicide. He tortured his girlfriend for over a 2-day period until he killed her, beat her, burned her, just completely tortured her. He had a mild intellectual disability. He was found incompetent to stand trial. I have to say, from day one, I tried to fight this because he gave a statement to the detectives and went toe-to-toe with the detectives, like changed his story when they confronted him. He ultimately admitted to killing his girlfriend. But the doctor said incompetent, tried to fight it unsuccessfully, and then 4 years in, he was in a facility. He was released into the community, into a program for individuals with disabilities. He was a horror in that program. He had to have a one-to-one 24/7 because he was aggressive and he targeted mostly women with severe disabilities.
Oh, great.
So the director got to know him. She and I talked. She said it was her opinion he was competent. She said, I'm telling you, he downplays his knowledge about the court system. So now we're at the 5-year mark. I file a motion to extend because in my plan, we're going to get him found competent and then have him go to trial. The judge, because of Ray v. State, so that the state can file to extend the time, but the courts have found in Ray v. State that the courts can't look at dangerousness. Well, that's always the main reason why you want to extend these. So lost the motion, case was dismissed. He walked out the door. That program tried to get him to stay, but he did not want to stay. So that night, he left the program. He's now on the streets. We wanted to recharge him, but we have no idea where he is. So that is just an example of why we need additional time. And again, only when the doctors say with additional time, we think it's likely this person will be competent, right?
Okay, thank you.
We're talking in the less than dozens in total in the statewide.
Right.
I mean, but we're talking about very dangerous people.
Thank you. Delegate, you mentioned some comments made. Would you like to address those?
Here, I'll let, since Tracy is much more articulate than I am.
Okay. I think I can, all right. do this quicker just because my memory is where this is. Okay. I'm sorry. Okay, so I heard earlier, so the Public Defender's Office gave some information that is just not accurate. One of the pieces of information they said is that when a person has their charges dismissed because they're not competent, they can be civilly committed. That only counts for half of the types of individuals. So we have individuals that have a mental illness that can be found incompetent. We have individuals that have an intellectual disability that can be found incompetent. For those defendants that have a mental illness, yes, the statute says if their charges are dismissed and they meet certain criteria, they can be civilly committed and then they will remain in the hospital. But as Mr. Turner testified, and I've learned, they do not keep people in the hospital very long once they are civilly committed. And once again, when they're civilly committed and discharged, they're out in the community with no supervision. But those are people with mental illness. The part that was inaccurate, when you have a defendant that has an intellectual disability, they cannot be civilly committed. The statute only allows the court to commit them to DDA, the Department of Developmental Disabilities Administration, for a total of 21 days. And in that 21-day period, DDA has a hearing and they look at the defendant to see what services this person needs. They look at, do they have a disability? Do they need services? And if they need services, what is the least restrictive? And then they offer this person services. They don't talk about dangerousness. They don't assess for dangerousness. So if you have a defendant with an intellectual disability, like my defendant who I said walked, he was self-sufficient. He was not the type that they would say he needs to be services in a program. So no, civil commitment does not apply in the statute for defendants with a intellectual disability. And then the other part I already touched on when they said that defendants go in the hospitals and don't get treatment while they're incompetent. That's just, for the cases that I've had, that's just simply not true. Like I said, that's why they're there. They're getting medicated, their mental illness is being stabilized so they can be made competent to stand trial. Oh, and then I already touched on the fact, the problems when somebody, when the cases are dismissed and it makes it difficult for the state to recharge.
Tracy, may I say something that's just very important?
Oh, I'm sorry. Yes.
With what you were saying there? When Catherine was released and then rearrested 2 weeks later after the release paper came out, she was deemed to be not dangerous, released with, like I said, 0 conditions. When she was brought back in, they found her to be dangerous 2 weeks later.
Thank you. Delegate Taylor?
Thank you, Madam Chair. Are you aware that Lisa Jordan from MCASA requested an amendment? What are your thoughts about?
I haven't reviewed the amendment, but I do know she submitted a favorable with an amendment, and we'll be happy to. I think this is going to go to public safety. And so if it does, I know that we all have a good relationship with her, so we'll try and work with her.
Okay, and I'll be there also. Just another question, just so I can have all the pieces. For a person that's deemed incompetent to stand trial, but we hold them somewhere, right? While we're treating them. Where is that place? Where are we holding them?
So if you have a defendant who has a mental illness, they are held, there's 5 state regional hospitals, but most of them go to either Clifton T. Perkins, Spring Grove, or Springfield in Sykesville. And again, the defendants that go into the hospital are only ones that an expert, a doctor, has deemed dangerous. We have some defendants who are incompetent pending trial, not dangerous. They're in the community. They're getting services in the community.
Yeah.
So those are for defendants with mental illness. For individuals that have intellectual disabilities, there's 2 facilities in the state of Maryland who, that's their population, individuals. But in my experience, the vast majority of defendants who have an intellectual disability end up in the community with services. I have 4 defendants right now, 2 charged with child rape. One, the charges, the facts are so horrific, I won't even share them because you won't be able to unhear them. And then I have 2 charged with molesting children. All 4 of them are incompetent in the community. They are all 4 at DDA facilities where they are getting all kinds of services that they've probably never had before in their lives. They go out in the community. They all have one-to-one, so they have people with them. So these individuals are not sitting in a facility, languishing away. They are actually in the community getting treatment. I would say probably living lives better than they ever had before. Because the law is you cannot keep somebody in more than the least restrictive. So the way it works is they are found not dangerous with conditions. And the conditions are they report to court monthly, they live in these group homes, they have their one-to-one. So that's how they're able to keep these individuals in the community and safe and, protecting public safety at the same time. Does that answer your question?
It did.
Okay.
Yeah, thank you.
Thank you. That concludes the favorable testimony. Oh, I'm sorry, Delegate McComas, please.
Said group home, because I've got all kinds of, so I'm thinking, what kind of a group home is it, and what if they get out of line?
And you're right, I should not have said group home, quite
Pardon?
frankly.
I'm sorry.
That's kind of saying, so they are in, there's different programs. They're more like assisted living programs for individuals that have intellectual disabilities. These programs all are run by DDA. They are in a setting where they have somebody from DDA there 24/7. So it's not like when you think of a group home, just, people in a home, not supervised. They are in a DDA facility.
But what I'm kind of concerned about is that, okay, they're in a DDA facility, but some of those folks in that facility have never committed a crime and aren't awaiting criminal, to get it together to to go through a criminal trial. And that kind of concerns me because, is that the case, that it's just wherever they can get a bed and a roof over their head?
No, in my experience, they truly do place these defendants in programs that they've worked with and that are known for keeping the defendants and the people in the programs safe. And like the one example I was giving you, he was in this program that we use it a lot, and they're just wonderful. And they actually had people with him one-to-one because he was targeting their more vulnerable population. So, honestly, our hands are kind of tied. If I had my way, honestly, my child rapist would be in a facility. But because of the way the law is written and because we don't want to violate the rights of people with disabilities, we are able to have these individuals in the community with this supervision that keeps the public safe, but also provides them the supervision and the treatment that they need.
Well, I guess what I'm worried about is the other folks that are in that facility, a home or something, because I know folks that are, they're living with folks, what do I want to say, with the disability community, but they're, they're not criminals. One guy works for the sheriff's department, but he's not all there, and his family's not there to take care of him. So I don't know. That's kind of weird.
Thank you very much.
Thank you.
We have the amendment from Mikasa. I just forwarded to Ms. Varda. We're going to look at it and see if we can work on it.
Thank you. Is Mr. Benjamin Charlton here? Great. And then we have Ms. Margolis online, and that's our unfavorable. Since you're here, we'll start with you, Mr. Charlton.
Thank you, Acting Chair Embry, fellow delegates, for your time this evening. My name is Benjamin Charlton. I'm an assistant public defender with the Forensic Mental Health Division in the Office of the Public Defender. We are asking that you issue an unfavorable report on this bill because this bill punishes people who are largely voiceless and vulnerable because of disabilities that they have no choice about having, for the fact that they have those disabilities. So there's two categories of disabled people who are largely going to be affected by this bill. The first are those with extreme and persistent psychoses. Right, if it's not extreme or persistent, after 5 years of forced medication, they usually become competent, usually within the first year, but we do check-ins in Baltimore City where I've handled many cases with Mrs. Varda. It's every 6 months, and a psychologist who is separate from the treatment group examines the individual to see if they are competent or not. They perform a complete battery of tests that include tests to determine whether or not the person is malingering. Malingering being the word that psychologists use for people who are faking their disability to gain an advantage. So they're tested for that every 6 months, and if they continue to be competent, they continue to be held. Eventually, the other group of people, so those people suffering from psychosis, sometimes the medication works and they become competent again relatively quickly, and sometimes it does not, and the psychoses persist throughout the course of 5 years of being forcibly medicated. The other group who is largely affected by this bill are the intellectually disabled. While they are held, they go to the Potomac Center, the SET unit at the Potomac Center specifically, where they are to receive education on a daily basis. There are classes every day that they must attend. But because of the nature of their intellectual disabilities, they do not achieve competency over the course of those 5 years.
Thank you very much. Ms. Margolis?
Thank you. Good evening. My name is Leslie Seid-Margolis. I'm a managing attorney and policy counsel at Disability Rights Maryland, which is the protection and advocacy agency for the state. We have significant concerns about House Bill 180. They're detailed in our written testimony, which also does include possible amendments that we think would address the proponents' concerns. The weight of social science research demonstrates that an individual who is found incompetent to stand trial and who is not restored to competency within 5 years is not likely to be restored to competency in 10 years. Research shows that 80% of people will be restored to competency within 90 to 120 days. House Bill 180 would result in detention of additional people in our state hospitals for longer periods of time, whether or not they require this level of care. Maryland currently has more than 200 detained individuals awaiting transfers to state hospitals. We routinely see such individuals waiting for months, often in solitary confinement, sometimes naked, often without any mental health treatment. In these conditions, individuals decompensate further, and competency restoration becomes even more challenging. Passage of House Bill 180 would exacerbate this problem. Fewer hospital beds would be available because current patients would remain in state hospitals for longer periods of time. Further, maintaining charges for extended periods of time when an individual is not practically able to be restored to competency violates the United States Constitution. Primarily, House Bill 180 is unnecessary for two reasons. First, because the Maryland Department of Health is already required to involuntarily commit someone whose charges have been dismissed and who is still adjudged to be dangerous. And two, the second reason is because Maryland law already contains an exception permitting an extension of time prior to dismissal of charges on a showing of good cause to the state. For these reasons and for the additional reasons outlined in our testimony, DRM opposes House Bill 180 and urges an unfavorable report. Thank you.
Thank you. Do we have any questions? Seeing no questions,
Thank you.